Right. Good morning, all. Is everybody present?
Good morning, my lady. We are here for
Morning, my lady.
Are all parties present?
Good morning, my lady.
Morning. Right.
Morning, my lady.
Mr. Klopper, good morning. Mr. Klopper, are you present?
Yes, I'm here.
Good. I think as per the arrangement yesterday, you will start off today.
Indeed, my lady.
Okay, and before you do, I just want to say, I don't see any reason why we shouldn't finish today. You know, it's really unnecessary to drag this matter on any further. Yesterday, Mr. Hodis was able to finish his address in respect of two respondents, you know, fairly quickly. I think it's just an hour and 5 minutes or something. And Mr. Ellis was able to do it in under an hour. So I'm proposing that you start off now and you use the first session, the hour. And then when we resume at 11:30, Mr. Keller can proceed. And hopefully we'll have still a bit of time before 1 o'clock, and then Mr. Arendse can start his reply. Does that suit everybody?
Indeed, from my side, my lady, I anticipated that I will most probably take about an hour to go through the points I wish to indicate,
Yes.
lady.
In any event, I see that your heads, which were filed late, take all the same points that have already been raised in any event.
Yes, yes, my lady. There's a lot of duplication, and I will not regurgitate the same arguments over and over.
Yeah, and then of course, you know, with regard to the late filing, I don't know why it was filed so late. I see there's no explanation on record, albeit that the applicant has indicated that they will simply be dealing with anything extra or new in reply. But I think it's important for us to also, you know, it goes back to what I said on Monday about observing the rules, respecting the rules, and acting in accordance therewith. I'm not sure why your heads were filed so late.
Yes, my lady. The heads, first of all, doesn't raise any issue which is not raised in the substantive answering affidavit. So there's nothing new we submit in the heads. And secondly, the heads, indeed, unfortunately, there was a bit of a glitch over between Friday and Monday. But yes, we sincerely apologize for any delay and any inconvenience. But I will deal with mostly facts, which your lady will, as I go through my arguments and try to curtail the proceedings as best as possible without not putting my client's case properly before the tribunal.
Yes, it's just that, you know, as I said, the rules are there for a reason, and one should, as far as possible, respect those rules, because it inconveniences parties, and especially the presiding officer likes to read in advance, whether or not it's exactly the same things in the papers. There's always something in the heads that might assist and give direction or indication of the direction in which the particular litigant is going to go. So, you know, as far as observance of rules, I'm always disappointed and a bit troubled when people at that late hour, and your heads were filed after the hearing started, or actually 10 minutes before, although that it was emailed, I think, to me in the middle of the day, but we were busy, and it only came to my attention that evening. So, you know, it's that sort of thing which I think we need to guard against. And ensure that the rules, which are there for a purpose, are in fact observed.
As I said, my lady, my apologies for any inconvenience.
Right. So
I'll try to go and stick to the time indication I've indicated. If I may proceed, my lady,
yes,
right from the start, your lady will have to look at what is the case against the sixth respondent. Now, the sixth respondent is one of two different categories. There are two different categories of respondents in this matter. That is the contractor categories and the professional service providers. And the sixth
But
respondent
is a PSP, right? A professional
Yes.
service provider.
Yes, yes. It's there's reference to the acronym PSP.
Yes.
And there's a major difference between the contractual relationships, the appointment relationships in those two parties. And I want to emphasize right from the beginning that throughout this application, the SIU simply failed to distinguish between the two vastly different processes regarding contractors in the one hand and professional service providers on the other hand. And that must always be considered throughout the context of the matter. I want to start off with just reiterating to your lady what the six respondents' contentions are. In paragraph 9 of the Armstrong affidavit, which starts at the case lines reference 097-10, paragraph 9 through to paragraph 17 of that affidavit, Malady, the sixth respondent emphatically and clearly indicates that the sixth respondent and its employees have not been involved in any conduct unbecoming, anything wrong, and any contravention of any rules or anything. No dishonesty, no untruthfully, nothing of that. It is strictly and very emphatically, pertinently denied. The SIU, in their reply to that, does not take issue with that. So we submit to your lady, if we compare what the reply to that is, that from the SIU's case, from the allegations which they made against the sixth respondent in the anti-dissipation application, the forerunner to this application, there was vast and vague statements of fraud and corruption and all those type of indications. It all boiled down and it fizzled out through the proceedings in this matter to a situation where Mr. Arendse, on behalf of the SIU, can only argue at best that there was a technical issues, as he said in his argument. The SIU has totally abandoned the serious allegations of fraud and unbecoming on any or of any nature by the sixth respondent. And that's very important also to take that into consideration. The second point I want to go to is the issue about the tribunal not being a court with inherent jurisdiction to review. I'm not going to rehash the arguments presented by Mr. Tsane. His arguments I fully support in those circumstances. I just want to confirm that based on exactly the same arguments and on exactly the same interpretation of the case law, which was so eloquently put forward by my colleague, the sixth respondent's argument is that based on that legal argument, that should be the end of this application. This tribunal is not a court with an inherent jurisdiction to review, and the proceedings, the nature of the proceedings attempted to be instituted by the SIU in this tribunal is wrong, and it cannot be accepted, and this application should be dismissed there.
You say it's wrong in the sense that it's in the wrong forum.
It's in the wrong forum. Any review application as is attempted, whether it is in terms of PAJA or in terms of constitution, is in the wrong forum. The tribunal does not have jurisdiction to hear that, as was already argued by my colleagues before you, and we fully support that, and we stand and rely on that. And we say, if that issue goes against the SIU, that's the end of the matter. We submit. The next point I want to go to is the application of PAJA to this matter. My lady, you've heard arguments by my colleagues. I'm not going to rehash that, as I've already indicated.
I think Mr. Tsatsatwana went very extensively into that particular aspect.
Yes.
As Mr. Hodis, I think, also lingered
Yes.
on that point for quite a while.
Yes, my lady, and I want to state clearly, just for the record, that we also rely on that point. That's the sixth respondent, and we align ourselves with the previous arguments. I'm not going to repeat anything. I fully agree with that. I just want to point out to your lady a further aspect which my colleagues did not do, which I think is a very important aspect, which your lady must consider. And that is, on this particular point, during his argument, when this issue was discussed and argued by Mr. Arendse on behalf of the SIU, Mr. Arendse made the following statement in his argument. He stipulated and he explained to your lady that the SIU argues that the review is brought partly on behalf of the departments. That's now the 15, 16, and 17th respondent, and partly by the SIU itself. And then Mr. Arendse continued and he explained immediately after that, where he said the SIU cited the respondents, the state institutions as the respondents and not as co-applicants. Now, already that statement demonstrates clearly that there's a huge legal problem for the applicant. The applicant cannot launch a review application using two hats. The applicant cannot launch a review application on behalf of the state institutions, the departments, and simultaneously also on behalf of itself. It must choose. It cannot choose both. It cannot employ both methods. There cannot be a review under PAJA in terms of the SIU launching the review on its own behalf, and simultaneously a constitutional review on legality on a self-review. The applicant must choose. You cannot have your bread buttered on both sides, unfortunately. And that demonstrates, we submit to your lady, that this whole application was ill thought and the application was incorrectly drafted when it was started right from the beginning. Because the SIU, the applicant, did not know where they stand, they did not sort out what they're doing, and they took a scattergun approach where they threw everything into the air and hopefully something will stick. And that cannot be allowed. This is a clear indication of what is the conundrum and what is the problem between a self-review and a review under PAJA in those circumstances. And I submit that the facts of this matter demonstrate very clearly that this can never be regarded as a self-review. This is an independent review by the SIU, as Mr. Arendse placed the proviso in his argument that they cited the state institutions as respondents, not as co-applicants. And that is then obviously that causes, and the result of that is that this application fails to comply with PAJA, and this application is simply defective in that sense as well and to be dismissed. So we simply say on that point as well, the application must simply fail. The explanation by Mr. Arendse is basically the death knell for the application, and your lady should dismiss the application. The next point I want to deal with is the issue of the time delay. Now, again, also, my colleagues have dealt with the time delay. But, my lady, I wish to point out to your lady that all of my colleagues who actually dealt with the time delay in this matter was extremely handled the SIU's conduct in this matter with gloves. And the facts is important for you, lady, to consider. We submit that there was an extremely unreasonable delay in launching these proceedings. Now, let me clarify right from the beginning. This delay is applicable both to a review under the PAJA prescripts, under the PAJA regulations. I don't need to demonstrate and refer you, lady, to the 180-day rule stipulated in PAJA, in the Act. That has never been complied with, and obviously there's no application for any extension in terms of PAJA. There's simply nothing. So that I submit is clear. But then also, if we apply the Gajima judgment, as my colleagues refer to, and the principles there set about delays, there's also an extremely unreasonable delay in bringing this application to the tribunal. Now, I need to point out to you, lady, what is the extent of that delay. And for that reason, I want to take you, lady, to the facts. If I may invite you, lady, to go to the record, and I will refer to paragraph 028, and I will start at -1411.
Sorry, which bundle? I've got 26 files in front of me. Which bundle are you talking about?
My lady, all the respondents have only the case lines references, and the case lines reference is 028-1411.
028-11?
028-1411.
Oh, 1411.
Yes,
okay.
1411.
All right.
My lady, there your lady will find a report, investigation into the allegations relating to this project, this hospital project. This report was written by an attorney instructed by the 16th respondent. This report, the attorney is Mr. Ezra Matlala.
Sorry, by the 16th respondent, you said?
Yes, my lady. Now, this report by attorney Ezra Matlala, your lady will find starting under paragraph 028-1411, as I've indicated, and it's a substantial report. It runs through and it continues, just for your lady's reference, it continues all the way through to 028-1450. So it's about a 40-page report. Now, my lady, what is important of this report is the following. This report, and I will indicate to you, lady, already demonstrates serious questions to be investigated. But what is very important on the issue of time delay is at page 028-144, the cover letter of the report, your lady will see this report was
144? Is it 144? Page 144?
1411. 1411.
Is that where you're reading from?
Yes, my lady, and that's under paragraph 028. Your lady will see the date this report was completed was already the 20th of August 2020. And just above the date, your lady will see it's version number 6. So attorney Matlala started this investigation he conducted on behalf of the 16th respondent, obviously before the 20th of August. It's a 40-page report, extensive report dealing with various issues relating to this hospital project. And this report was finished and submitted to the 16th respondent by 20 August 2020. Now, at that stage, it was certain allegations have already been identified. That's when the clock started running. We've heard yesterday argument that about when the clock starts running. The clock doesn't start running when the SIU finished the investigation. The clock started running when any of the state institutions and or the SIU obtained information that needs attention. But it goes further. Under the same paragraph 028 at -1461, your lady will find a report, a memorandum submitted to the head of department of the 15th respondent.
That is the Department of Health.
That's correct, my lady. That report is dated 28 February 2021. This is also an extensive report, my lady. It starts at under paragraph 028, as I said, page 1461, and it carries through all the way in the papers until the recommendation is on page 1483. So it's a 23-page report. Right. Now, my lady, what is important of this report is what I need to point out to you, lady, on page paragraph 028 page 1461, paragraph 1 of the report, the following is stipulated. The purpose of this memorandum is to inform the acting head of department of a legal opinion that was received from Advocate N. Kassem SC on the refurbishment of the Western Deep Levels Hospital. So by end of February 2021, there was this report was prepared for the head of department. Already I'm not going to go through the whole report, my lady. Your lady have seen the papers, but very interesting. On page 1466, that is the case lines
Yes.
Under paragraph 10 of the report, there's a heading, the SIU investigation. So this report to the head of department already contains a paragraph under the heading SIU investigation. And very importantly, reference is made to the following. In paragraph 10.1, the first subparagraph, the Special Investigating Unit is in the process of conducting an investigation into the acquisition and refurbishment of the hospital. 10.2, the focus of the investigation is on alleged irregular appointment of contractors and professional service providers pertaining to the acquisition and refurbishment of the hospital. Paragraph 10.3, very important. Your lady should make a cross-reference there. The report to the head of department reads, due to COVID-19, an emergency procurement process was approved to acquire and refurbish the hospital. So this is by the legal department of the 16th respondent to the head of department of the 16th respondent. And it confirms that there was emergency procurement, and it confirms the SIU has at that stage already been involved. It goes further, my lady. In paragraph 14 of that report, that is at case lines 028-1479.
So just give me one moment, please.
I'll do, my lady, my apology.
Para 14, sorry, page
1479.
Yes.
That's all under the paragraph of 028. Right, paragraph 14 of the same report under the heading Consultations with Council and Site Inspection reads as follows. Paragraph 14.1. On 8 February 2021, a consultation was held with Council. The SIU was invited to the consultation to explain their ongoing investigation as set out above, as well as their preliminary findings. Paragraph 14.2. During consultation, the SIU explained that they have ascertained that the amount spent to date in the refurbishment of the hospital is approximately 376 million. The SIU appointed a quantity surveyor who indicated, past tense, that the account spend exceeds the reasonable value and the improvements that, of the improvements that were made to the hospital to date. So by 8 February 2011, the SIU has already disclosed, they already conducted an investigation, they already obtained...
Did you say 28 or 8?
8 February 2021. That's the date of the consultation, and that's when they disclosed this. So they disclosed by 8 February that they've already completed investigations to the sense that the quantity surveyor has already indicated to them and provided them with a report prior to 8 February. The same subparagraph continues and indicates that the SIU's junior counsel was involved in these meetings. We page over to 028-1480. The lady will find a subparagraph 14.7 of this report, which is recorded as follows. After further consultation was held with counsel on 17 February 2021, and this is the important aspect your lady should make a cross-reference to. I read, counsel advised to approach the High Court on an urgent basis for declaratory relief to the effect that the project must be stopped. So on 17 February 2021, opinions was received from counsel, and I'll demonstrate to you, lady, it was senior counsel and junior counsel, that immediate urgent relief is should be applied for in the High Court, not in the Tribunal, in the High Court, the correct forum. Just to demonstrate to your lady the senior counsel's memorandum, your lady will find that at the case lines reference 028-1452, and it goes through to 1459. At the bottom of page 1459, your lady will see it was signed by Advocate Nasir Qasim, SC, on the 19th of February 2021. At the first page of the memorandum, at page 1452, your lady will see the memorandum is addressed to the MSc, the head of department, the acting head of department of health. It was addressed to Mr. Karel van Heerden, who is the legal advisor who wrote the other report I just referred you, lady, to, and it is referred to Advocate Vrees, that's the SIU's junior counsel present in this matter. So from 20 August 2020, the departments and the SIU acted. In February 2021, the SIU and the departments received written legal advice to urgently approach the High Court. But nothing happened, my lady. Nothing was done. Now, my colleagues have already indicated to your lady, and this is common cause, that the project, the refurbishment, the work, the actual works, the construction works, continued right through 2021, and the completion was obtained on the 14th of December 2021.
14th or 4th?
4th, my apology, yes, indeed, my lady, 4 December 2021. But so that is 11 months later, the project is concluded. But for 11 months, nobody did anything. Contrary to a report from an attorney, a detailed report, contrary to a written advice by senior counsel, where the SIU's junior counsel is involved, Advocate Freers, contrary to an internal memorandum to the head of department, where specific reference is made that the senior counsel's advice, that's Advocate Kassim SC's advice, should be followed, nothing happened. So, my lady, the facts in this matter clearly demonstrate that the delays are not 4 months, as Mr. Arendse claims, between the finalization of the SIU's investigation and the launching of the main application on the 14th of December, as indicated in this matter. The delay started by no less than 20 August 2020 already. Now, your lady will, in context, take cognizance of the fact that by June, July of 2020, that's only when the progress towards the refurbishment started to get speed. So within the timeline is within a few months, the warning bells were sounded by Attorney Mtlala, and the 16th respondent commissioned this report at that stage already. But for months, we submit a delay of approximately 17 months. Nothing happened. Now, my lady, that is the facts. Now, if that fact is applied to PAJA, the 180-day requirement, we know it must be clear that PAJA has not been complied with, and we know that the applicant in this matter, the SIU, does not in their application make any reference to a request under the section of PAJA for an extension of time. So this application under PAJA is dead. In relation to a legality time frame, if your lady, we submit is bound by the Gajima ruling of the SCA, where the facts in relation to the delay is very similar to the facts in relation to the delay here. The department continued. The departments, various of them, continued. The contractors and the professional service providers were happy to continue with them, to let the work be done, let the work be continued, let expenses be incurred, notwithstanding warning lights already starting to flash in August 2020 with an extensive report by Attorney Mtlala.
Sorry, that's one of the 26 files protesting.
So, my lady, we have a factual situation which points no way, doesn't matter whether we classify this under PAJA or whether we classify this under constitutional legality. We have a clear improper delay of excess of a year over reasonable periods, over and above reasonable periods of more than 12 months, and nothing is said about that. There's no explanation for that in the application, in the founding papers by the SIU. There's no explanation at all. This whole issue is not dealt with, and we submit that demonstrate without any doubt that your lady should make a finding that also, as a result of time delay, this application is unreasonable and this application should be dismissed. It is shocking that when a report was received on the 20th of August 2020, that the review application or the attempted review application we would like to submit was only issued on the 14th of December 2021. That's months later. So we submit on that aspect, your lady should also dismiss this application, and the application is not suited for that reason as well. If I may then move to the next issue, my lady, and that's the actual appointment of our client, the sixth respondent, ProServe Consulting. My lady, the case attempted to be made out by the applicant against ProServe, the sixth respondent, started off and, as I've indicated, fizzled out. It started off during the anti-dissipation application, where allegations were simply made that the sixth respondent was not appointed through a tender process. Now, clearly, it cannot be, no other conclusion can be made than that when the anti-dissipation application was launched against the bank account of the sixth respondent, the SIU did not even understand that the sixth respondent, as a professional service provider, is appointed from a total different process as a tender process per contract. Clearly, there was no understanding about how the panel of service providers work, and there was no understanding that the sixth respondent went through a tender process in 2016 going through to 2017 to qualify to be placed on the panel of service providers by the relevant departments here, to be on a rotational basis selected from that panel. Now, that whole process was seemingly unknown to the SIU when they launched the anti-dissipation application. It was only when the sixth respondent came and opposed, or not opposed, but asked for a reconsideration, that, and the sixth respondent in its papers clearly demonstrated the method of how they were appointed, the sixth respondent as a service provider, that knowledge came to the SIU. That must be the only conclusion. Now, what happened in that regard? The sixth respondent provided a version under oath of how they went through a tender process in 2016 going through to 2017, and the appointment after a successful tender process proceeded in early 2017. Now, that was disclosed in the anti-dissipation proceedings. And let me demonstrate to you, lady, what was found by this tribunal. And there we have to go to the judgment of Justice Modiba, which we will find, your lady will find that the case line's reference is 074. And it starts at page 14 and it goes through, the judgment goes through to 074-43.
Mm-hmm.
Now, my lady, in that judgment, Justice Modiba with this issue of the appointment of the sixth respondent. In paragraph 46 of the judgment, this is starting to be discussed with. That is at 074-31, the page number. Now, in paragraph 46, the learned judge wrote, the SIU alleges that ProServe was appointed to the GID panel on 17 January 2020 for a period of 3 years under the reference there. Well, we can split hairs, but that was what the sixth respondent actually alleged, and which the SIU accepted. Paragraph 47 is the important thing. ProServe denies that. Let me just go back. When ProServe demonstrated their appointment, the SIU's response to that was no, but the panel was not valid anymore. But then what ProServe did is they provided evidence that the panel, the time period of the panel was correctly extended. Now I'm going to show you, lady, where the evidence, my lady, I'm going to show you where the evidence about that is. But let me first indicate what the judgment of this tribunal is in paragraph 47. It says, ProServe denies these allegations as controverted them, attaching documents to its answering affidavit that substantiate its response. The GDID appointed ProServe to the relevant panel on 20 February 2017. The appointment would endure for 36 months. The 36 months period would have expired on 19 February 2020. On 11 February 2020, prior to the expiry of the 36-month period, the GDID extended ProServe's appointment to 12 June 2020. ProServe did not attach a letter informing it of its extension, but attached an internal memo recording the GDID resolution authorizing the extension. Now that document your lady will find, I'm not going to read it out, but your lady will find it at 009-103, going through to 009-105. And my lady, that is a contract extension authorized in terms of the procurements, which was authorized by Mr. Madayu, who was at that stage the Chief Financial Officer of the 16th respondent. And it was authorized by Mr. Makumazini, who is the head of department of the 16th respondent. And both of them authorized that on the 11th of February, as is demonstrated in that document. Now, that's the facts which this tribunal already found. And if I can go back to paragraph 48 of the judgment, the approved deviation specifically authorized SCM to use the panel of approved service providers. That's now for this particular project. ProServe falls within this ambit. For these reasons, the SIU has not made out a prima facie case again, that ProServe was unlawfully and irregularly appointed to the AGA hospital project. So here's a founding in a judgment that the SIU did not make a case that there's any impropriety or wrongness with the appointment of the sixth respondent outline. And that is repeated in paragraph 55 of the judgment. So it's very clear. The SIU knew that this tribunal already made a finding. Prima facie, there's no evidence that the sixth respondent is appointed incorrectly. Now, what would one have expected of an applicant who then, after that, launch further application against the sixth respondent and others, but specifically against the sixth respondent, requesting for this sixth respondent's appointment to be reviewed and set aside. We've already, the applicant, this SIU already has been, there's a judgment by the tribunal which says prima facie they haven't proved their case against the sixth respondent. So what would one expect? One would expect in the founding affidavit of this review application that the SIU has taken specific effort to demonstrate that that prima facie finding, or that finding that prima facie they haven't proved their case, should be overturned by this tribunal. But they haven't. They have not done anything. No further evidence is provided. No further detailed arguments are provided to overturn or demonstrate incorrectly that finding of the tribunal. Nothing. Mr. Arendse continues to argue that the sixth respondent was not correctly appointed. Now, let's consider the law. This tribunal already found that, made a positive finding that the sixth respondent was correctly appointed in terms of the panel procedure, a tender process in 2017, allowing them onto a panel and then a selection from that panel. That's already found. For the applicant to demonstrate to your lady in these proceedings that the appointment of the sixth respondent should be set aside, what the applicant must do is nothing but reviewing the tender process in 2017 and reviewing the decisions made in 2017 to place the sixth respondent on the panel. That's the burden of proof the applicant is challenged with against the sixth respondent. Now, my lady, they have not even, they don't ask that relief. They don't attempt that relief. That appointment, that successful tender, that procurement process, that successful tender and that appointment to the panel stands unchallenged. We submit, my lady, based on the Plascon rule and emphasized by the Reitman judgment of the SCA, which your lady has already been referred to and which I'm sure your lady knows very well, where the Supreme Court of Appeal says when a party is confronted with allegations where there's specific knowledge in his possession about that, he cannot simply deny that or run over it. He must in detail, legal representatives must in detail deal with those facts. None of those facts, detailed facts, has been dealt with. Nothing. And we submit that the approach by the SIU, the applicant attempting to set aside the sixth respondent's appointment without attacking the 2017 tender process and the decision by that tender board and tender committee to allow the sixth respondent to the panel of service providers, if that is untainted, then this application is dead. Because what happened, and this is now common cause, what happened is the 16th respondent, in conjunction with the 15th respondent, simply selected the sixth respondent from that panel. There was no procurement process involved. It was a simple selection from the panel. The panel which is regulated by Treasury regulations, the panel which is regulated by industry regulations, that panel was used to select the sixth respondent. And I dare say that specific point which I'm now arguing applies to every single professional service provider which was appointed in this particular contract, which comes from the panel. So the SIU simply barked up the wrong tree by saying the appointment of the professional service providers to this project stands to be declared attacked.
So therefore you're saying that because they were lawfully, properly and correctly on the panel, there was no need to follow a tender process for this contract in respect of the hospital.
Indeed, my lady. That's how the procurement process by regulated by that's how the 16th respondents procurement processes works.
And that, I take it, will be the object of establishing that panel.
Yes. This is exactly the same argument which Mr. Ellis yesterday explained to you, lady, that panel is it's a source of potential service providers which is simply picked off. There's no new procurement process when the department picks someone from that panel. It's simply a rotational basis. And that's exactly what the sixth respondent explains to your lady in their answering affidavit. And I'm not going to deal with every single aspect of the answering affidavit, but your lady should, if I can invite your lady just to make a cross-reference, it is explained in paragraphs 87 all the way through to paragraph 100 of the sixth respondent's answering affidavit, and that your lady will find at 097-46 going through all the way to 097-53. Now there the explanation is given of how this panel works and how the sixth respondent actually knew nothing about the hospital project beforehand until being appointed. They were not invited to provide a quotation. They were not invited to indicate what their cost will be. What a professional service provider on the panel gets is simply a letter or a message that you are appointed to this project because we draw you from the panel. After that, the service provider can simply say, I've got time, I can accept the appointment, and then he accepts the appointment and it continues. Or possibly he can say, sorry, I don't have the capacity, I'm not taking this appointment, take someone else. I'm maybe overwhelmed with other work. And that's the process which was followed, and that's undisputed. We've seen the SIU in the reply to that explanation, and the highlight, with all respect to the SIU's, from the SIU's reply is the following, summarized. They say there's no paper trail of how the selection took place. That's a selection by the 16th respondent from the panel. Well, lady, that's irrelevant. The process of appointment from the panel is not disputed. That's common cause. And further, if the SIU wanted to, with honesty and with vigor, attack the selection of the sixth respondent and other professional service providers from the panel, they had to go and investigate that. what caused the SIU not, after this has been disclosed in answering affidavits, to go back to Treasury to see what is the panel, who's on the panel. Those are public documents. It's public information. What stopped the SIU of investigating, going and looking at the process, the panel, the selection from the panel rotational basis by the 16th respondent? They simply didn't do that. That's what one would have expected. Not an simple saying, well, there's no paperwork from that. There's no burden of proof on the 6th respondent. The burden of proof is on the applicant at all times. So the facts demonstrate, my lady, that there is absolutely no substance in the allegations made by Mr. Du Toit in his affidavits or by the arguments of Mr. Arendse that procurement process regarding the 6th respondent, and for that matter the other professional service providers who was on the panel, was not in accordance to the procedure. And what makes it more important, my lady, is that the panel from which these service providers were selected, nothing changed as a result of the emergency procurement regulations which came into effect after the COVID pandemic. The 16th respondent continued to use exactly the same panel and exactly the same process. Now, whether this selection of the 6th respondent from the panel took place in 2019, before we had the COVID pandemic, or during 2020, as it was early 2020, during the COVID panic and pandemic and the emergency there, the process followed by the 16th respondent was exactly the same. There was no deviation. It's a simple selection from the panel, and there's no evidence at all to demonstrate anything else. In terms of the Plascon and Reitman, your lady must accept that. And that demonstrate, we submit, my lady, very clear that there's no evidence before this tribunal that demonstrate there's anything wrong with the process, the procurement process which was followed to appoint the 6th respondent. Nothing wrong with that. It was a standard procedure in those circumstances. And that we submit, my lady, to summarize on this particular point, although I can carry on, that there is no basis and no evidence, no direct evidence before this tribunal for your lady to consider even why the appointment of the 6th respondent should be reviewed. There's simply no jurisdictional basis for that allegation. My lady, this aspect runs closely with the determination of the price or the fees, not the price, the fees charged by the 6th respondent as a professional service provider, and I'll get back to that fees in a moment when I go to the next part, which is the issue about overcharging. So just wrapping up on this particular point, there's no evidence anywhere in this application that the standard procurement process regarding the appointment of the 6th respondent from the panel was done incorrectly or not in accordance with the standard procedure employed by the 16th respondent. There's simply no evidence. And the result of that we submit is that this tribunal, if the tribunal gets there, which we submit should not even be necessary, this tribunal cannot find, as Justice Modiba already found it in her judgment, there's no evidence, there's nothing which indicates that there was any problem or any incorrect step or any impropriety in the appointment of the sixth respondent. And we submit your lady should, if your lady come there, should simply find that there's no basis and therefore the appointment cannot be attacked and it cannot be set aside in those circumstances. And that should be also the end of the application in that request. My lady, I quickly want to deal with the last point, and that's the issue of overcharging. My lady, the issue of overcharging seems to me the main point which the applicant, the SIU, is raising before this tribunal. Everything else is vague now, and now the overcharging point comes in. And we submit simply right from the beginning that this overcharging point is wrong and it's totally incorrect. And Mr. Orange's argument to say that there's a competitive process which is required and it must be cost effective in relation to the sixth respondent is simply wrong. It's totally a misconception of what happens. The fees for a professional service provider, and this has now been fizzled out to be common cause without any doubt. The fees are determined by legislation, the reference to various acts, the Architectural Act, Quantity Surveyors Act. It's promulgated it's gazetted in terms of the regulations, how the fees are determined. The fees are determined in a very simple way. It is a simple mathematical calculation of a percentage of the contract price. There cannot be, in relation to any professional service provider who's on the panel and who's selected from the panel, any issue about comparative process and cost-effective requirement, because that's all regulated by legislation. And that legislation is not attacked by the SIU. Now, the Mutara report, which is so strongly relied on by the applicant in this particular case, the Mutara report in fact confirms this, my lady, because the Mutara report, if I can just quickly, and I need to, I'm not going to read it into the record for your lady, but just make a, your lady can make a reference to that. If we go to the evaluation part of the Mutara report, and that your lady will find at 087-2, and it runs through basically to 087, excuse me, let me just get to the last page, 34, my apology. 087-2 to 087-34. Now, just by a mere glance at that report, that report deals with the three sections, LOA 1, LOA 2, LOA 3. The sixth respondent was involved in LOA 1. Now, on all the calculations regarding the fees of the professional service providers, your lady will see in that report, they follow exactly that mathematical calculation. It's a simple percentage of the contract price. There's no...
I just want to confirm, footnote 12 on page 12 of your heads, that's the report you're referring to.
Yes, my lady.
Yeah, because I see you've rechristened the reports. I was wondering if there's a Mutara and a Matala report.
My apology, my lady, if there was a finger fault or a typing error there, my lady. I hope it didn't cause any confusion. It should not.
No, no.
But in the report, my lady, your lady will find that the report confirms that the calculation of the fees is a percentage. And the important aspect of the report is at paragraph 3.5 on the reference page 087-16. It is there recorded that the sixth respondent's fee was eventually dealt with as a percentage of 12.49% of the total cost of the portion LOA1. And that's a simple question and a simple calculation. Now, getting back to Mr. Arendt's argument that there must be a comparative process and it must be cost effective. Already, with all due respect, that's untenable. Every single service provider, every single entity on the panel which was appointed or could have been appointed would have been allowed and provided exactly the same fee of 12.49%. Whether it's A, B, C, D, E, or F, or whatever, we can continue. We've seen from the documents there were 169 service providers on the panel. And that fee, using that percentage, the sixth respondent has no say in that, nothing. What transpires, and this is clear from the facts, is that the contractors who submit their contract price, which is negotiated as it was in this particular case, as Mr. Ellis yesterday clearly demonstrated to your lady, when the contractors eventually contract on a price with the state institution, that amount, that bottom line price, is simply used, and 12.49% of that is calculated, and that's the sixth respondent's fee. And whether it's the sixth respondent or whether it's 100 other different entities, the fee is exactly the same. So there cannot be a question of competitive process. The fee is exactly the same.
That will be for all PSPs on the panel.
Every single person on the panel would simply charge, as the plaintiff did, as the sixth respondent did, 12.49% of the total price of the portion LOA1. Not a cent difference. There cannot be any competitive process because nobody is allowed to charge anything else.
Mm-hmm.
Now, this is common cause. It can never be disputed. Now, the argument regarding overcharging, which this application fizzled into, result from a calculation of in the Mutara report, which says, but the contractors relating to the portion LOA1, that is now Dipatsi Trading, which your lady can just make a note, that is the 8th respondent, and Tenga Holdings, that you lady know is the 13th respondent. Those were the two contractors. Now, the argument attempted to be proposed to your lady in this tribunal in relation to the 6th respondent's overcharging is that as a result of those two contractors overcharging, the sum of 12.49%, the 6th respondent's fee, consequently also constitutes overcharging. Now, the fallacy in that argument is to allege overcharging against an party, a company like the 6th respondent. That company must be involved in overcharging. There must be a deliberate act of overcharging. Now, where the 6th respondent's fee is not determined by the 6th respondent, it's got absolutely no input in how its fee is calculated. The fee in this case, and that's the undisputed evidence, was actually determined by it seems to be an agreement between the 3rd, the 4th respondent, the 16th and the 15th respondent, and then a purchase order was issued to the 6th respondent. That's the common cause evidence. The 6th relies on calculations by third parties for its fee. How can you allege that party overcharges? It's simply untenable in common sense and in law. But let me demonstrate to you, lady, on the SIU's own version. There's no overcharging. As a matter of fact, the sixth respondent was not paid its full fee. And for that, I need to demonstrate to your lady, taking your lady to the papers with a few aspects. And I'll hope I can do this in a few minutes in the time indication I've left to your lady. Now, your lady, I need to quickly refer your lady to a few points in the evidence. The first point in the evidence, which I need to refer your lady to, is again back to the summary of the expert Mutara report. And that summary, I want to refer your lady to page 087-13, where the bills of quantities of Tenga Holdings is discussed. And the result at the bottom of the line is an indication that Tenga Holdings, that's the contractor relevant to the portion where our client was involved, overcharged in the amount of 12,387,480 and 55. Now, the methodology of the Mutara report is that 12 million rand must be deducted from the contract price, and then the percentage of my client's fee, 12.49%, should be alleges that the sixth respondent overcharged, which we say can never happen because they were not involved in that. But let me demonstrate to you, lady, that's simply wrong. The 13th respondent demonstrated, and I need to take your lady to that. If I can just get my documents sorted. You can just have a moment, my lady. The 13th respondent demonstrated in their affidavit. Now, I'm referring you, lady, to the 13th respondent because the Mutara report and the applicants indicate as a result of their overcharging, the sixth respondent consequently overcharged. But the allegations against the 13th respondent is simply wrong. Now, Mr. Houder's client demonstrated this. Mr. Houder's didn't deal with this in his argument yesterday, and I'm not arguing Mr. Houder's case for him, but I am sure he will agree with my line of argument. In the answering affidavit by the 13th respondent at case lines 096-277, there your lady will find a tax invoice of a service provider or a air conditioning provider who provided products to the 13th respondent. Your lady will see that is GREE, Gree Products South Africa. There is listed the air conditioning condensers and units which was provided and which was installed. Now, this is the crux of the mistake in the Mutara report. On that document, your lady will see and 9 condenser units. So it's 18 very, very expensive items, and together each filter, fan filter unit and each condenser unit, together they work to be a large air conditioning unit. Now, this hospital required 9 of those units, 9 of those huge individual units. Where you lady can see that is my client's design. Your lady will find at case lines 096-276. There your lady will find a drawing which your lady will see was prepared by my client, the 6th respondent, which the 13th respondent used in its construction. And there in that drawing, there's a clear indication that there are 9 air conditioning units in total. 9, consisting of 18 huge parts, which needs to be connected to, so it's 9 units. Right. Now, my lady, in the Mutara report, there's a large mistake. Now, that is demonstrated by the comments of the Mutara report in relation to the bill of quantities of the 13th respondent. Now, that your lady will find, and I hope your lady have got access to these documents. At case lines page 087, paragraph 087-226. That's part of the Mutara report. Now, all the respondents, my lady, were provided electronic copies. I'm not sure if your lady's got electronic copies or hard copies.
No, I've got hard copies. I don't have access to case line. That's why I say there's 26 files in front of me and I need to access it, but it is in front of me.
I appreciate that, my lady. Now, my lady, I hope your lady's got these documents, but on our electronic version at case lines page 08, paragraph 087-226, that's the page number 226, there's a hyperlink. And if you click on that hyperlink electronically, the bill of quantities of the 13th respondent, together with comments by the Mutara experts, is demonstrated there. And I hope your lady will find that. Now, that whole document...
Give me one moment and I'll tell you. There is a master index here, and I will just let you know now. Let's have a look. You say it's on page 226.
Yes, of paragraph 087. Yes.
I do have 087-226, and it just talks about an index, a document file.
But if your lady have a printed copy of that page, your lady will see right at the top there's a small reference which says hyperlink.
Yes.
Now that's an access electronically if for us, and I presume other that is opened with the comments on that. And that is
what I've got is a reviewed bill of quantities, and then the actual thing starts on page 233.
Yes, my lady, but that's not the hyperlink. That's not the bill of quantities of the 13th respondent.
Well, then I don't know what is, because I have that, and then it's got comments in red. For instance, if you look at page 235, item 3, it says documentation pack received is incomplete. Some valuation certificates are not. Is that not the one?
No, my lady, that's the next document of the report but the hyperlink, as I've indicated to you, lady, opens up the document. But what we'll do, my lady, is because the hyperlink gives us access to that bill of quantities with the comments to that. When you open that hyperlink, the bill of quantities doesn't have page numbers, unfortunately, in our case and all the respondents' cases. So that's why I'm not sure if you ladies got that document. But what we'll do is we'll make sure that we'll actually, from our side, that we actually print out a copy, and maybe if we can mail it to your registrar and make sure you've got it. But unfortunately, those pages are not paginated, but the items on that bill is numbered sequentially. It starts with number 1 and it goes down. It's a very long document. It goes down to number 738. But what is important is items number 655, 656, 658, and 659. And these are the bills of quantity which correlates with these air conditioning units. Now, I'll demonstrate to you, lady, that it is common cause that there was a serious mistake by the Matara report. And what the Matara report did, it mistakenly calculated that there's only 1 unit, not 9.
Has that not been corrected subsequently? I recall that there was an adjustment.
Yes, my lady, I'll demonstrate to you, lady. But this is the crux of the allegation against my client. Now, the amount there, which is subtracted, my lady, is the amount of in excess of 12 million rand from the 13th respondent's bill. And we submit that's a major mistake, and it's common cause it's a major mistake, because your lady is quite right. That mistake has been clearly demonstrated and recorded in the answering affidavit by the 13th respondent. And that your lady will find, if your lady want to make a cross-reference, paragraph 115.5 to 115.13 of the 13th respondent's answering affidavit, and that's at case lines 096-34 and onwards. Now there, the 13th respondent under oath tells your lady that...
What's the paragraphs again, Mr. Klopper?
115.5 to 115.13.
Okay.
And that's...
If I have that, then it will be easy to find, yes.
Yes, my lady, that's at the case lines page numbers is 096-34.
Onwards, yes, I've got that.
And onwards. Now there the 13th respondent explains this mistake. Now the important thing is, my lady, what does the applicant say about that? And what the applicant says, my lord, this is, my lady, this is the important crux of the matter. What the applicant says about this mistake, your lady will find in the applicant's replying affidavit at paragraph 605.7.
Just what? Give me the page first, please.
That's 100-159.
159 para 605.
605.7.
Okay.
Right. There the following is under oath in reply by the applicant. However, in light of the information now provided by the 13th respondent, the costing of the 9 package units and the 9 extraction systems appears reasonable. Right, it goes further at paragraph 606 of the same replying affidavit, just at the next page. Because of the above issue pointed out by the 13th respondent having resulted in a change of Mr. Swoboda's assessment as to overcharging, he is of the view that this individual change by the 13th respondent for 9 package units and 9 extraction systems appear reasonable. Right. So there's confirmation that there's a 9,387,000 rand mistake Now, my lady, that's common cause. Now, the result of that is very simple. If we add back the amount of 12,387,000 odd rand onto the cost of the 13th respondent, if we add that back, because it was incorrectly subtracted, that leaves us with a contract price of for portion LOA1 of 142,276,949,000 rands. And if your lady make the simple calculation, I've indicated it in my heads of argument, if we take that amount, the adjusted amount, the conceded amount, that's now excluding any other possible mistakes by the Muchara report, which we submit there could be many, but excluding that, just on this one mistake. If we take the adjusted amount and we calculated 12.49%, which is my client's fee, then the result is, and I've indicated it in paragraph 50 of my heads, my lady, the result is 17,733 rands, 690 rands and 40 cents. The SIU attempts to make a case to say the sixth respondent has been overpaid. The sixth respondent has been paid less than this amount, about 700 rand less than this. So on this concession by the SIU, their allocation, or their allegation, my apology, their allegation that the sixth respondent overcharged is wrong and to be rejected on their own concession. Simply wrong. It doesn't exist. But my lady, they wish to come drag us through lots of litigation, millions of rands of legal fees without having a case against the sixth respondent on their own version, as it is now conceded. And that's where the sixth respondent found itself in before this tribunal. Now, my lady, Mr. Arendse argues just and equitable principles must be applied. My lady, what is just and equitable in this case? We've demonstrated to your lady that there's various, well, apart from the points taken against that this review application is simply defective right from the beginning, and this court that cannot deal with it. We've demonstrated on the facts for your lady that the appointment by the sixth respondent is unassailable, it's untouchable, it's correct. The due process has been followed and there's nothing tainted. There's nothing to review in regard to the appointment of the sixth respondent. But we've gone further. We've demonstrated to your lady that on the true facts, and the calculations can't lie, there was not 1 cent of overcharge. The amount of money which was paid to the sixth respondent is less than what the applicant's expert says it should have been. By 700 rands odd, but it's less. So there's no case for overcharge against the sixth respondent. Now, what is just and equitable in these circumstances? Well, lady, just and equitable is that the respondent is unjustly and unequitably dragged through this whole process of very expensive litigation where the applicant cannot even prove its case, which we submit is in any way wrong, but they can't even prove their own allegations. and their own allegations and their own experts demonstrate they are simply wrong. But they simply proceed. We say that is tantamount to vexatiousness. When Mrs. Justice Madiba made her judgment, which I referred your lady to, and indicated there's no prima facie evidence that the sixth respondent is involved in any unlawful act or any misdirection or anything which should be can be frowned upon. The SIU was obliged as a state institution with a presidential mandate to revisit and rethink their actions. They simply did not. They were like a bull in a china shop, just continuing, running forward with vague allegations, which is unsubstantiated. Throughout this process, the sixth respondent is tainted and has been tainted as a party against which the applicant, the SIU, launches application alleging conduct unbecoming, claiming money back, tainting the sixth respondent in the industry as a person or an entity where involved in shenanigans, which is simply wrong. There's no factual basis, and there was never a factual basis from the start. What is just and equitable in those circumstances, my lady? Your lady cannot, under just and equitable, even consider making any order against the sixth respondent. There's no basis for that. My lady, that brings us to the last aspect of costs, my lady. We submit, my lady, as I've now indicated on various aspects, this application is totally defective and should be dismissed. There's no just and equitable remedy possibly available to the applicant in this case, my lady. My lady, the applicant launched an anti-dissipation application against the sixth respondent on an ex parte basis. That application resulted in a reconsideration application. Your lady have seen the record of that. I don't need to go through that. I've already indicated to your lady the judgment which was granted. And then that culminated in this application, which is a huge application where a large amount of legal costs, time, expenses are incurred. All of that, and in the end of the day, there's no case made out against the sixth respondent, we submit. And that's what the facts demonstrate. So in those circumstances, my lady, we submit, your lady, we are entitled to a cost order if this application is, as we submit, should be dismissed against our client. And my lady, very importantly, I must remind again, and I've clearly indicated it in paragraph 52 of my heads of argument. One should never forget the cost orders in relation to reserved costs. My lady, there are two cost orders already in this matter where costs were reserved. That's the one in paragraph 8 of the 17 September 2021 order. That's the original preservation order. And then there's another cost order in paragraph 3 of the judgment of Mrs. Justice Madiba, which I referred you to, of 21 January 2022. Both those cost orders reserve the costs of those litigious matters for determination by your lady in this matter. So we submit, my lady, the sixth respondent is not only entitled to a cost order when this application is dismissed, we submit the sixth respondent is also entitled to cost orders for the cost which was reserved in those two orders as well. Your lady have seen what Mrs. Justice Madiba has ordered in her judgment, and we submit there's simply no case against our client in this matter before you, lady, and the matter should be dismissed. So we submit the cost order, or the order and the cost order, which I've tried to phrase to assist your lady in paragraph 52 of my heads. That is the order which your lady should make in relation to the sixth respondent in this application, my lady. My lady, if I may just quickly see with my attorney here if there's anything I need to raise further.
Is that it?
My lady, one last aspect, and this is an elephant in the room. Where is the losses? Where did the losses suffered by the state institutions actually fell in this matter? Those losses, which is the task of the SIU to go and recover, that's their mandate in section 4 of the SIU Act. They must go and recover those costs. Where does that cost fall and where does it lie? It lies with the first and second respondent. They have been enriched with millions. Their property has been improved by millions. The SIU tells you, this tribunal, they are not asking any relief against the first and second respondent. Why, we don't know. No explanation is provided. We submit on the basis of alternative remedy available, similar to that of interdicts. Alternative remedy available is simply for the SIU together take hands with the 15th, 16th and 17th respondent and recover the money from the first and second respondent who received the benefit of millions of money which they've got now in their property. And that's what should have happened in this matter, my lady. That's our submissions, except if there's anything which your lady wish to question me about.
Yeah, that's fine. Thank you. You've done a comprehensive argument, and thank you very much, Mr. Klopper.
Thank you, my lady.
Right. I see it's now 25 to 12. Let's take a short adjournment. We can resume at 12, and Mr. Keller can kick off at 12 o'clock.
My lady,
Thank you.
Sorry. Yes, Ms. Governor.
my lady, before we take the adjournment, might I just address you on one brief point?
Yes.
My lady, yesterday Mr. Hodes excused himself, but I remain in attendance for the 10th and 13th respondents. Insofar as Mr. Klopper made submissions concerning the 13th respondent, we associate ourselves therewith.
Okay. Thank you, Ms. Governor. Thank you very much. We'll take the adjournment then and resume at 12 o'clock. Thank you. morning again. Is everybody on board?
Thank you,
my
Lady.
lady.
Good.
Thank you.
Everyone's here. Mr. Keller, I believe it's your turn now.
Thank you, my lady. Lady, I confirm my appearance on behalf of the fourth respondent in this matter. My lady, yesterday, if I'm not mistaken, you issued an order in as far as costs are concerned in relation to the lateness of the filing of, in fact, the heads of argument. Can I get a clarity from your ladyship, since it has now been noted and noticed that there were many respondents that also filed their heads, albeit without a condonation, that were also late. The order also extends to them in the event of any person that has incurred costs. Can I get clarity from that?
As far as your heads are concerned, it seemed that the applicant and none of the others took issue with the late filing of your heads. It's just that the applicant asked to be given an opportunity to respond thereto in reply, should there be anything new that he wishes to, that you would have raised. And I granted that. So I said, as far as the heads of the various respondents, that will be the fourth, sixth, and seventh, fourth and seventh, the fourth and seventh, and then of course yesterday morning was the sixth respondent. As far as the heads are concerned, then yes, I have condoned that. So you can continue with that. What the applicant is objecting to is the filing of that Rule 65 application. And there's no application for condonation. And so I just need a brief address from you on that, because the applicant's allegation or the applicant's view is that it must not be admitted.
Thank you. Malady, I'm going to address you on that particular issue. And I will show you, Malady, in fact, through, I will demonstrate.
I'm sorry, I can't hear you. It's very unclear. Your sound is very poor. I can barely hear you.
Yes, can you hear me now, Malady?
Now I can, yes.
Thank you, my lady. My lady, I will demonstrate to you, my lady, through, in fact, various case law that, my lady, the notice itself, it was a question of a formality just to bring to the attention of, in fact, the applicant, what will be argued on behalf of the fourth respondent. But in essence, my lady, there is no basis in law to prevent any party in court to advance a point of law. A point of law, my lady, with respect, is in fact taken from the cases, and also it serves at some stage as a guidance to court on what in fact correct path of law should be on a particular matter. My lady, all I'm saying is that my lady colleague, under the circumstances, let me say the applicant has not shown you any basis in law as to why you should not allow these points of law to be advanced.
He hardly had an opportunity, did he? That's the whole point. The parties have not had an opportunity. While everybody has the right to bring whatever they need to or they think will advance their case to court, it's got to be done within the framework of the rules. It's also got to be done in consideration to the other parties. You're not the only party in this matter. And obviously, the applicant is on the back foot as far as that is concerned. I haven't even read it because it's, as far as I'm concerned, it's not properly before me. So, you know, I just want to hear you on that. I'm going to give Mr. Arendse an opportunity to tell me what his attitude is, whether it's still the same or not, and then we'll take it from there. So that's what I'm saying. You know, what is the reason after the start of the hearing that we get these documents filed without any reference to anybody, no information, no advising the applicant or the tribunal that, listen, I filed documents this morning, that was on the morning of the hearing, and I discovered this late at night. So, you know, that's what I want to hear. What is the reason that I should actually accept this?
Just to give a brief background in this matter, in as far as my involvement is concerned, Malady, I'm very much new in this matter, Malady. I received it as voluminous as the files can be during the course of last week, in particular between Thursday and Friday. But I managed to receive all the documents over the weekend in as far as this matter is concerned. So, my lady, through the effort of reading and going through, in fact, all the pleadings involved in this matter, as voluminous as they appear, I managed, my lady, to deal with those issues as outlined, in fact, in the Rule 65 notice. So, my lady, those are the circumstances that actually involves me as counsel in this matter. But over and above that, my lady, the issue of filing a notice, my lady, in this particular issue, my lady, the main part is that, my lady, even if the notice was not filed, my lady, but the case law in this regard allows the report respondent to raise these particular points of law. And then, my lady, the case that I'm going to seek refuge from is the case, my lady, of Barkhuizen, is the case of Barkhuizen versus Napier 2007, Volume 5, SA.
Sorry, I didn't hear that. What is that reference?
It's a Barkhuizen.
Yeah.
Versus Napier.
Yeah.
2007.
Yeah.
Volume 5, SA. 323 CC.
Sorry, 323. Is it 323?
In bracket. Thank you.
Is it 323?
323, thank you.
The sound is very sketchy still. You sort of going, it becomes muffled, so I can't hear you. And what, where is this judgment from? Where does it emanate from?
In bracket CC, Novo J said the following.
No, sorry, 323. Which court are we talking about here?
Yes, it's a CC judgment, my lady.
It's a what?
The CC judgment. The CC judgment in bracket CC.
Concord, yes.
Yes, and Novo J said the following at paragraph 39. The mere fact that a point of law is raised for the first time on appeal is not itself sufficient reason for refusing to consider it. If the point is covered by the pleadings, and if its consideration on the appeal involves no unfairness to the other party against whom it is directed, this court may, in the exercise of its discretion, consider the point. Unfairness may arise where, for example, a party would not have agreed on material facts or on only those facts stated in the agreed statement of facts that had the party been aware that there were other legal issues involved. So I'll stop there for this particular moment. So, my lady, the consideration, my lady, when the point of law is being raised for the first time is the unfairness on the part of the other party, or the prejudice on the part of the other party. However, another qualification is that, my lady, same should be covered by the pleadings. In this particular instance, my lady, I will deal with the second part. The second part is that, my lady, the issue of Rule 53, it has been covered by the pleadings. And if my memory serves me well,
by your pleadings.
That is correct, my lady. It has been covered, my lady, by the pleadings in this particular matter. And same has been raised by the other respondents as well.
Well, if it's covered in your pleadings, why do you need to now file a separate application? If it's covered in your pleadings, then it must simply be argued. Why do you have to file a separate pleading?
My lady, this is a point of law, my lady. If the pleadings, my lady, you do not plead the law, you plead the facts. My lady. In this particular instance, the case law says if the point of law is apparent or else it's covered by the pleadings, then one can raise it, my lady. And the secondary issue is that, my lady, if it does not going to create an unfairness on the part of the other party, then those are the two inquiries, my lady, that the leadership should consider in dealing with, in fact, the points of law as raised by the fourth respondent. The secondary issue, my lady, is the one of unfairness or prejudice on the part of, in fact, the applicant. They have not demonstrated any prejudice at this stage, unless perhaps later on when they are going to be given an opportunity. But at this stage, my lady, it can never be that they will simply say it is late, then therefore, or else it has been raised at this stage, then therefore it should not be, it should be ignored. That is not the case, what the case law says. And the secondary case law, my lady, that I'm going to refer to is the case, my lady, in which the case law that I've referred to, Barkhuizen, has been also referred to, is the case of Provincial Commissioner, Gauteng SAPS
Yes.
versus Mgoni
Yes.
in brackets 89-0/11.
Yes.
In brackets 2013 Zaska
Mm-hmm.
2 in brackets 32 February 2013. Paragraph 27 of the judgment. It is indeed open to a party to raise a new point of law and appeal for the first time, with a proviso that it does not result in unfairness to the other party, that it does not raise new factual issue and does not cause prejudice. So the very same principle, Maledi, has been endorsed even by the SCA in this particular regard. And again, Maledi, if I may again, if I refer to a judgment of the High Court Gauteng Local Division, I'm going to upload this judgment later on, but it's between JMN and the Commissioner for the South African Revenue Service. Case number A3096 of 2019. Paragraph 33, our courts have permitted an appellant to rely on a new point of law on appeal, as the court will not be precluded from giving the right decision on accepted facts merely because a party failed to raise a legal point as a result of an error of law on his part. I'll stop there, Marine. This particular judgment also, Marine, if I may make a submission, is that it simply affirms the position that I was dealing with earlier on with the earlier judgment. My lady, the submission is that, my lady, a point of law, in fact, it's like a compass to a court, my lady. It simply establishes or reveals a principle that has been established in a certain case law. To an extent that, my lady, a court, my lady, as stated clearly in the High Court judgment, should be very slow or should not allow a situation whereby it could be prevented from hearing a point of law. However, my lady, this issue becomes more settled. This issue, my lady, becomes more settled in the judgment of Kusa, CUSA versus Tawo Young.
I can't hear you at all. Sorry, what was the name of the parties?
Kusa, CUSA
Yes.
versus Tawo, TAO.
Yes.
YING.
Yes.
Metal Industries.
Mm-hmm.
It's a constitutional court judgment. The case number is CCT 40/07. Just 1 second, please, Marie. I'd like to draw your ladyship's attention to paragraph 68 of this judgment. Paragraph 68 of this judgment, my lady, reads as follows. These principles are, however, subject to one qualification. Where a point of law is apparent on the papers, but the common approach of the parties proceeds on a wrong perception of what the law is, a court is not only entitled, but is in fact also obliged mero moto to raise a point of law and require the parties to deal therewith. There comes the most important part of this judgment. Otherwise, the result will be a decision premised on an incorrect application of the law that would infringe the principle of legality. My lady, I will stop there at this particular moment. But the submission that I would like to make is that, my lady, the court simply says, on paragraph 68, my lady, also affirms the position that has been adopted by, in fact, the other cases. It simply says, my lady, if the parties in the form of the applicant will push for the matter, for the point of law not to be raised, that will deprive the court, my lady, of an established principle in that area. To an extent that, my lady, the court, it can be highly possible that it will arrive at a decision but that is based on an incorrect part of the law. And in this particular instance, the judgment takes it further, my lady. It simply says, my lady, the court, my lady, mero moto, even on the verge, my lady, of in fact, taking a judgment, if the court is of the view that after considering the matter that there is a certain point of law in which, in fact, the parties have not, in fact, dealt with on the papers, the court can set down the matter and provide the parties with an opportunity to address the court on that particular issue, which is apparent on the papers. If that, my lady, can also be done by the court, my lady, this also affirms, my lady, what has been said here, that if in a litigant, at the very last moment, my lady, if it is apparent from my lady, the papers, and then, my lady, it goes without saying that under the circumstances, my lady, the point of law should be raised.
Thank you. Are those your submissions?
My lady, those are my submission, is that, my lady, that there is no basis upon which, my lady, these points of law should not be heard, and in line with the case law, in particular the SCA judgments, the High Court judgment, and lastly, the Constitutional Court judgment, which, my lady, allows a parties, my lady, to deal with the points of law. And, my lady, the last submission that I would like to make is that, my lady, in these circumstances, my lady, the notice was, my lady, uploaded as far back as Monday. Today is Wednesday. So, my lady, it was the whole day on Monday and Tuesday, and also today for the applicant, to know exactly, my lady, what issues he has to deal with in as far as that point of law is concerned. So I submit that, my lady, those points of law, my lady, the respondents must be allowed to deal with them accordingly. That is my last submission, my lady, on that particular issue. My lady, in dealing with, my lady, with the issue, my lady, of Rule 53.
Sorry?
In dealing with the issue, my lady, of Rule 53, your ladyship.
I'm not even allowing you to go that far yet. But are you going into now the merits of the application that you are bringing?
No, my lady, I'm not dealing with them. I'm connecting, my lady, the issue of the point of the issue to be apparent from the pleadings.
Yes.
My lady, the issue, my lady, is pertinent, my lady. The issue.
I'm really struggling to hear you, Mr. Keller. I don't know if it's your sound or what it is, but it just keeps breaking up. And if I'm not going to catch everything you're saying, we're going to have a problem.
Thank you. Just 1 second, please, my lady. I just want to ask for a quick assistance to use another device so that you can hear me. Just 1 second, please, my lady.
Yes. Okay.
Can I? I'm just quickly connecting to another device, my lady.
Okay.
Thank you. Can you hear me now, my lady?
I can, but it's quite a bit of feedback. Just carry on.
Thank you. Can you hear me now, my lady?
Yes, I can hear you now.
Thank you, thank you. My lady, in an attempt, my lady,
There's a lot of feedback. Somebody's got their mic on.
thank you, thank you. In an attempt, my lady, to demonstrate to you, my lady, the connection between, in fact, the issue that we are raising and the pleadings. Your ladyship, in fact, will notice that the applicant in this particular regard filed an amended notice of motion. Secondly, filed a supplementary affidavit. And secondly, my lady, made an attempt, my lady, as well to comply with Rule 53 by filing, in fact, in the attempt of involving Rule 3512. So, my lady, those are the issues, and my lady, the parties were given an opportunity to file Rule 3512 in an attempt, my lady, to obtain the documents, in fact, in as far as this application is concerned. So, my lady, flowing from that, my lady, it is apparent that, my lady, under the circumstances that, my lady, the applicant, in doing so, in fact, was actually dealing with the dispatching of, with an attempt, it was an attempt to deal with the dispatching of records. I'm not saying, my lady, it was the actual dispatching of records, but it was just an attempt to deal with dispatching of records. So if that, my lady, appeared on the papers, then, my lady, the applicant, the fourth respondent points, my lady, in as far as, in fact, creating a connection between the point of law raised in as far as Rule 53 is concerned, is well taken, my lady, under the circumstances. That is the connection, my lady. Furthermore, my lady, we are of the view that, my lady, the applicant ought to have, my lady, relied on Rule 53. The applicant ought to have relied on Rule 53, and the notice of motion ought to have been drafted in line with what is required under Rule 53. And in these particular circumstances, that was not done. The notice of motion, as it appears, my lady, before you, or in these papers, it can never be said that same was crafted in line with Rule 53. And secondary to that, my lady, we will address you on another point of law that says that, my lady, even the Rule 3512 notice, it is not, can never be equivalent to Rule 53. So, my lady, with that being said, my lady, the points of law as taken in the notice, my lady, are connected, my ladies, to what appears in these particular papers. In simpler terms, my lady, we are saying the applicant ought not to have invoked Rule 3512 in a review application. And secondly, the applicant ought to have followed the Rule 53 procedure in the dispatching of records. And, my lady, if one notices the conduct of the applicant, it's a mixture of an attempt to comply with Rule 53 and a mixture of an attempt not to comply with Rule 53. And, my lady, it is our submission that the applicant cannot run with the wolves and chase with the dogs. And we submit further, my lady, that the applicant, as the SIU, my lady, does not have a separate law to deal with its issues, and the citizens of the Republic have another law to deal with their issues. That can never be, my lady. We have got one law in the Republic, and one, all of us, we are all equal before it.
Yes, are those your submissions?
My lady, those are my submissions, my lady. And in as far, my lady, the last one, my lady, in as far as the issue of the unfairness, my lady, it has not been, in as far as I've heard the applicant yesterday, he has not demonstrated what are his shortcomings or, in fact, the prejudice or the unfairness that has been resulted, in fact, from, in fact, these points of law as raised by the fourth respondent. And secondly, he has not addressed you as well as to the connection between the points of law and the pleadings, and in particular those of the fourth respondent. So, my lady, I submit that, my lady. I submit that, my lady, the proper case has been made out, my lady, for the applicant. Even without a notice, without relying on the notice, my lady, I can come, my lady, in line with that case law and raise those points of law. But in this instance, my lady, he has been given them prior to my submissions. Thank you, my lady.
Thank you, Mr. Aronson. Mr. Aronson, are you with us?
I am, my lady. I'm just waiting for Ms. Freeze to just unfreeze me.
Okay.
My lady, yeah, just two things. Of course, I think we all know, and the court knows, that points of law may be raised at any time, even on appeal, if it arises, always referred to in the pleadings. But of course, the very important caveat is that it must be raised timeously. It happens frequently when some of us, my colleagues, when we appear in an appeal matter, full bench, SCA, or even the Constitutional Court, and you take over or step in for another colleague, or new attorneys brief you, you re-look at the record and you come up with legal points that weren't raised in the first place, and provided there's a satisfactory explanation of why it's done late, and of course, importantly, that it's covered by the pleadings, it could, and in some instances, is admitted by the court. So that's on the first leg. But it's on the second leg, my lady, that we would submit your ladyship shouldn't entertain the point at all, and that is on the issue of lateness. It's just hopelessly late, my lady. This matter started on Monday. The Rule 653 notice was loaded on Monday. We hadn't considered it properly, even as I speak, because we want to conclude this matter in the time allocated, and we are also busy preparing our replies so that we can conform to your ladyship's directions to even finish today if possible. We haven't looked at the matter, so the prejudice, my lady, is self-evident. However, I think that it has been raised, although not pursued by some of the respondents, the issue of the Rule 53 record. And to that extent, I think we, even in our initial address, we did address your ladyship on that, my lady. And our submissions would be the same. This matter has been regulated by the Judge President of the Tribunal from the onset. In February, the minute of that case management meeting has now been uploaded on the 11th of February 2022. All the respondents were cited, including the fourth respondent. It appears from the attendance register, my lady, that the fourth respondent elected, or for some reason, is not recorded as having attended the meeting, but some of my other colleagues who are participating in this case were Mr. Oudis then for the 5th, 10th, and 12th respondent, Mr. Klopper for the 6th respondent, So they were in that meeting, and the issue of the Rule 3512 and the applicant's report, that was raised, my lady, and subsequent to that, several of the respondents took the opportunity to file their 3512 notices. Secondly, my lady, the SIU was not the decision maker in this matter, and it is trite that a Rule 53 application relates to documentation in particular, which underlies or informs the impugned decision or the decision that's now taken on review, and it then gives the party applying to have that decision set aside to have insight into further documentation. And of course, it could lead to one of two things. One, when they get the documentation informing the decision, they may not pursue the review any longer. But if they do see information, then they get the opportunity to supplement their papers. Now, in this case, we know it is not contested. The investigation, apart from other criticisms about delay and so on, the investigation was done. All the respondents had an opportunity to, in fact, Mr. De Tooy requested all of the respondents to cooperate. The attitude was one of obstruction and frustration. So the documents that is before the court here is what we could collect and collate. And to the extent there was other documentation, of course, there's lots of other documentation falling peculiarly within the control and possession of the respondents, which they've elected not to make available to the court. And of course, the applicant have no other way of subpoenaing or compelling them to provide these documents. And to that extent, the Rule 53 procedure is not available to the SIU, and we would submit is not an appropriate way to deal with a matter of this nature. And of course, we refer also to quite a number of SIU cases where this exact same approach has been followed, my lady. So we make two submissions. The one is it should be ignored because of lateness, and alternatively, two, to the extent that your ladyship still entertains the point, then we've made our submissions that it has no merit, my lady.
Court, my lady.
Just give me a moment, please. Well, Mr. Arendse, what I am interested in is you say the second leg is prejudice, and what accusation has been leveled against you is that you have not demonstrated, although that it was uploaded on Monday when the matter started, you have not demonstrated what prejudice you will suffer.
My lady, I did say, to be fair, that to the extent that this point has also been taken by some of the other respondents, but as I recall, and I speak subject to correction during the course of this week, has not been pursued with any enthusiasm or vigor by any of the respondents that have raised this issue. We have responded to that issue. I dealt with it in opening argument, and I could deal with it again. The prejudice relates to the time that we haven't had to deal with the matter properly. Yes, my lady, that's the prejudice, particularly to us as the counsel for the SIU, my lady.
And in order to give you that time, it means we must adjourn this matter.
My lady, I don't think adjourn to give us time. Because we were hoping that during the lunch break, the hour that we would have there, we would also try and finish our reply to submissions made by our colleagues thus far, my lady. But that hour, even that hour now during the lunchtime, will be taken up by having to deal with this issue.
So you're saying that you're not going to have time really to respond. That's what I want to hear.
Well, we can make time, but it's going to impact, my lady, on the conclusion of this matter. You indicated this morning, perhaps optimistically, that we would finish today. If this will now have a knock-on effect, and we will almost certainly have to probably finish during the course of have the whole of tomorrow morning to finish the matter in its entirety, which I think is at this stage is inevitable. I think Mr. Klopper, yeah, he obviously took his time, which he was entitled to, but it took a bit longer than expected. So we are going to go into tomorrow morning, and if we are, then we would ask for some time. I would think at the outer limit, an hour to look at this particular issue, Melanie.
So what is your proposal then? If I decide to allow the application, are you saying that you want the time today to prepare that, and then we start with arguments tomorrow?
I think if we could, I don't know what other submissions Mr. Kettler is going to make, other submissions other than this particular point. And if he has, then perhaps he should be permitted to continue and conclude, and then we can start with our reply still this afternoon and see how far we go, and then if it has to roll over until tomorrow morning, then finish then, Mariki.
No, but we have to deal with whether this Rule 6.5 application is going to be permitted to, and going to, if I'm going to allow it or not. We can't move on until we have that, because obviously whatever submissions are now going to be made by the fourth respondent would have to include whatever he's raised in his 6.5 application. If I say no, then he must proceed without that.
Can we make maybe a practical suggestion, my lady, is to take the lunch adjournment now, and we will look at this application and address your ladyship after lunch on this, so that your ladyship might be in a position then to make a ruling.
Yes, but we need to be crisp and short, because, I mean, there's no point in spending a whole day on this application, which should not have been in the first place, or should not even be allowed. That is my view, but I want to hear what you have to say. And if you need some time to do that, and you say you can do it in the lunch break, then we will take the lunch break now.
As you please.
Can I address the leadership in this particular regard? The leadership appears to have made their mind in as far as this application is concerned.
I said that was my prima facie view, and I'm hearing what you have to say, just like it was my prima facie view that I wasn't going to allow your condemnation application for your heads because it's out of time, it's in contravention of the rules, and that is something that should be frowned upon. But when I hear the parties and I hear their views, then I make a ruling. So prima facie, you are out of time, you are in complete contravention of the rules of this tribunal, the practices of litigation. You've taken your opponents by surprise. You've not given them a chance. So prima facie, my question is this properly before me? When I hear you, then I will decide whether I will change my view. And that's what I'm giving.
My lady, I've addressed you in as far as, in fact, a binding authority of the Constitutional Court judgment is concerned.
Yes, but you haven't given your opponent a chance to talk. And the prejudice is what he wants to address on because he hasn't had a chance to look at it. So he says he needs to look at your application again, simply because there's many respondents to whom he has to respond. They've all made submissions and he still has to respond. And what he said is he hasn't had the time. He needs now this time to just let me finish, please, Mr. Keller. Keep interrupting me. When he is done, and he says, then he will address me at when we resume, and then I can make a decision on whether to allow that application or not. It's irrespective of whether there's authority in the form of the Constitutional Court. I have to decide this matter on the facts here. This is, for one, is not an appeal. Secondly, there's no wrong point of law that the parties are proceeding on. It is a question purely on the lateness, the extreme lateness and the prejudice. And that's what I've got to decide on. And Mr. Arendse has not had a chance to completely address me on that issue of prejudice. And he says he needs time to look at the application again. So I'm not, and in spite of your argument, I've still got to wait to hear his response before I make a decision.
Already, all I'm asking is for an opportunity to deal with the issues that he has just mentioned now. And then so that whenever he comes back after lunch, I can also deal with the issues that he's going to be dealing with thereafter.
I'd like you to deal with it at one hit, not piecemeal. He says he's just talking about the prejudice because he's not had time to deal with the application. Because I said he hasn't addressed me on the issue of prejudice. And it's because he hasn't had time. He's been preparing his response to the previous arguments by the various respondents, and he hasn't had time to look at your application. So he wants this time, the lunch break, to look at it, and he will address me then on the issue of prejudice after lunch. And once he's done, then you'll have your chance to reply.
Thank you, Marek. That would also suit me.
Yes, because, I can't hear you piecemeal after I hear him say one word and then give him an opportunity to say another 10 words and then give you an opportunity to respond. It just simply doesn't work that way. So we'll take the lunch adjournment now and we'll hear you after lunch, Mr. Arendse.
Yes, Malay, thank you.
At 2:00, we take the lunch adjournment now.
As the court pleases.
It pleases the court, Marek.
Okay. Good afternoon. Is everybody back on board?
Good afternoon, my lady. We are.
Okay, everyone here. All right, then.
We are here, my lady.
Good. Mr. Arendse, you were then going to continue your address.
Thank you, my lady. We were going to address, or are going to address you on the issue of prejudice to the applicant, given the exceptionally late notice of the fourth respondent, delivered on the morning of the first day of this hearing, dates having been agreed and subsequently directed by the president of this tribunal, at great difficulty given the number of counsel involved in this matter. Up until now, given the cooperation between and amongst the parties and with the leave of the court, we've managed to accommodate one another to a large extent, so that we can utilize the precious time of this tribunal and the judicial resource embodied by you to hear this matter. And then we get this, my lady, just totally unacceptable. But I address you nevertheless on the merits of this application. Your ladyship would have seen from the case management minutes that ultimately.
Sorry, just one moment, Mr. Arendse. Somebody's mic is on and we're getting quite a lot of feedback. So if you have your mic on, please mute. Thank you.
My lady, yeah, your ladyship would have seen from the case management meeting minutes that ultimately the tribunal, the president directed that the respondents file their answering affidavits on or before the 29th of July 2022. By and large, the respondents opposing have complied with that, and some were a few days late.
I think you're looking, sorry, Mr. Arendse, I think you're looking at an older one. I think the most recent one was they all had until the 10th of October this year to file. Just give me a minute, I'll tell you which minute that is. The 15th of June, respondents shall file, oh yes, 15th of July, I beg your pardon, yes. That was on the 15th of June.
Yeah.
Was there another case management meeting after that, do you know?
No, my lady.
All right, so everyone was required to file by the 8th, by the 15th of July.
29th of July, my lady.
29th of July, beg your pardon.
Yeah.
Yeah. Yes, sorry, you were saying?
So that date is important because that is also the date by which any of the parties, in this case the fourth respondent, that intended to file a Rule 65D3 notice should have filed that notice. So if I may just read the sub-rule, my lady, the relevant one, 65D.
Just before you do, Mr. Arendse, maybe I'm a little confused. Which minute did you read from that the 29th of July was set as the date for heads?
07-10. 07-10.
10th of July.
15th of June.
15th of June, I am looking at it. It says that respondents to file heads by 10 October, and the hearing will be 14 to 18 November.
That's
So
the heads, my lady, 10th of October.
heads. Yeah. Heads. That's what I'm talking about. What were they supposed to do by the 29th of July then?
If they had any Rule 5D3 notice of objection, then that would be the trigger date, my lady, the cutoff date.
Okay.
If I may just read the rule, my lady.
Yes, certainly.
Any person opposing the grant of an order sought in the notice of motion shall, and this is sub-Roman 3, if he intends to raise any question of law only, he shall deliver notice of his intention to do so within the time stated in the preceding subparagraph setting forth such question. And we say that that period is the same period as the time for the delivery of the answering affidavit, i.e. 15 days after the delivery of the notice of intention to oppose. So the first point that we make is that this notice ought to have been filed by on or before the 29th of July. And in this case, it was filed hopelessly late on the 14th of November 2022, the first day of the hearing of this matter. And worse, my lady, without any condonation application. The fourth respondent applied for condonation for the late filing of the heads of argument. And I think they also mentioned their practice note, but but they never applied for condonation for the late filing of this note. We just know from their condonation application, and I think from my colleagues addressed to you earlier, that the reason or the main reason seems to have been a change in their legal team or counsel, and that they battled to get hold of counsel who wasn't available. But that's right, my lady. It's no excuse.
Yes. Mm-hmm.
Now, my lady, looking at the notice itself, 4 points of law are raised purportedly or allegedly, although one of them we submit is not a point of law, which is they claim that we haven't applied for condonation for the delay in bringing this review application. And the other one is, again, is not a law point. It amounts really to an irregular step which they contend for, and that is that we haven't filed, or we didn't bring our amendment to the notice of motion in terms of Rule 28 of the Uniform Rules, which deals with amendments to pleadings. But in that event, my lady, that would amount to an irregular step. And again, the Uniform Rules makes provision for how that must be dealt with. You send the other party I think a Rule 32 notice, and give the party the opportunity to regularize whatever the irregular step was that was allegedly taken, but not in, it's not dealt with in a 653 D3 notice. So, my lady, my colleague made the point, and I readily accepted it. I thought, oh, well, maybe it is there. And that is, again, a well-established approach to matters of points of law. If it's foreshadowed in the pleadings, and albeit that it's raised late, the court will nevertheless deal with it. And there's even apart from I haven't looked at Barkhuizen and Napier for a while, but I looked during the lunchtime at another Concord case, judgment of Justice Ngobo, as he then was, where he also said it's actually even the duty of the court where a point of law appears on the pleadings, and even where none of the parties have raised it or dealt with it, it is the duty of the court to deal with it. Why? Because the court must get things right. They must get the law right. They must get their decision right. Now, in this case, these points are not, with respect to my colleague, it is not raised on the papers. The relevant paragraphs, my lady, are at 09334, which is their answering affidavit.
Just give me a moment, please. I need to find it amongst all these. 093-34. Just a minute. Okay, the answering affidavit starts on 09312, right? But you're looking at 34.
Yes, my lady.
Yes.
So 093, that's paragraph 60. In fact, your ladyship will see that there's two headings in bold, just above paragraph 60. The fourth respondent's preliminary point.
Yes.
So the first one is the material disputes of fact, which requires leading of oral evidence. That's at paragraph 60. And at paragraph 72, this is the proposed solution to that issue that they raise at paragraph 72, which is at 09337. Therefore, they say, therefore, it is the fourth respondent's submission that in this regard, as it is entitled to do in terms of the uniform rules of court, request that this dispute on the figures, the amount, the alleged overcharging be referred to the hearing of oral evidence. So, my lady, there's no mention there's no complaint about Rule 53 at all. What was the other one? And in fact, on the pleadings, they accept the manner in which this application has been brought, save for their for them raising the issue about the dispute around the computation of the amounts and overcharging. So, my lady, we say that the prejudice that we face is that we weren't called upon to deal with this issue around Rule 53 because they do not contend in their answering affidavit that we fail to follow the provisions of Rule 53. It mentions nothing about it. There's no allegation that they are prejudiced because of documents that are allegedly missing, and that as a result, some harm may follow or flow from the fact that we have failed to follow Rule 53. There's no point taken by them that we have delayed with pursuing the review in December 2021. They're completely silent on it. They also do not take issue that we've allegedly amended our notice of motion without following Rule 28. So, in conclusion, on that point, my lady, we say that the this late notice of theirs is not in fact based on matter that has already been foreshadowed or raised in the answering affidavit and is therefore prejudicial to the applicant. And to the extent that they raise the issue of a dispute of fact, they themselves proffer a solution at paragraph 72, which is at 09337, where they say that in the light of the disputes on the figures, the amount and the alleged overcharging be referred to the hearing of oral evidence. Now they claim, my lady, in terms of Rule 65D3, they say that because of the disputes of fact, prayers 5 to 7 must be dismissed. That position now clearly contradicts what they say in the answering affidavit. So if we are called upon now, we would have to address those issues afresh, my lady. The issue of delay has been canvassed by some of the other respondents, but that's based on factual averments, my lady. The fourth respondent make no such averments, but they now contend that delay is a law point, and we submit it's clearly not the case. So we submit, my lady, given that they are not foreshadowed in the answering papers, there's no basis for them to raise any law points at this late stage. There's no condemnation as to why it's late, even if they could raise them because they are foreshadowed in the answering papers. We submit this would be highly prejudicial. It is highly prejudicial to the applicant and ought to be dismissed. And the court should, with respect, show its displeasure with the late filing of this by making a special cost order against the fourth respondent for this type of abuse and dismiss the application with costs on a punitive scale, Malene.
Thank you, Mr. Arendse. Are those your submissions?
Those are our submissions. Thank you, Malene.
Good. Then it leaves me to then inquire if any of the other respondents have any inputs to make, any comments to make. If you could just indicate, please.
Not from our side, my lady.
Mr. Hodes, you're back with us. Right, so Mr. Hodes, you say on behalf of the 10th and the 13th respondent, you have no comments.
Yes, my lady.
Thank you. Anyone else?
My lady, on behalf of the third respondent, we've got no comment.
My lady, from our side, 6, same.
Thank you.
Nothing from the 7th respondent, my lady.
Okay.
Lady, we also, on behalf of the 13th, the 11th respondent, we do not have anything to add, save that we would not like this application to detain these proceedings or
Yes.
get into a postponement of any nature, as it pleases you, my lady.
All right, Mr. Keller, if you would like to reply. Mr. Keller, are you with us?
Thank you, my lady. I would like to take this opportunity and reply, but I must apologize, my lady, because of, in fact, connection problems. I had, in fact, certain, interruptions during the address of my colleague. I was struggling to get into the platform, but I managed to get the gist of his submissions. But where I did not, I would, in fact, humbly request the court to guide me in that regard.
Yes, certainly. I will.
My lady, first of all, my lady, the opposition to this application is sitting on deadly grounds.
Sorry, I didn't hear that. Is set on?
It's sitting, my lady, on incorrect grounds in as far as to what is expected of my colleague to be saying in as far as this particular Rule 65D3. My lady, without taking you back to the considerations on the inquiry that the court must have in the light of, in fact, new points of law are concerned, the inquiry is twofold. One, is it connected to the pleadings? The second one, is there any element of unfairness on the part of the other party? So, my lady, I'm going to confine myself to that. I will deal with other issues later on. I can see that my colleague, he went over and above that and dealt and categorized, in fact, in the form of saying, this does not qualify as a point of law. I think that's what is expected in defense of this once the court has pronounced as to whether they should be accepted or not. But be that as it may, my lady, I will deal with these two. My lady, my lady colleague earlier on, before the adjournment, the complaint that he had was that of lateness, of which, my lady, in as far as lateness is concerned, he has not addressed you as to what has he done from Monday until today. And secondly, he did not address you again as to how much time does he need to deal with this from today onwards. And in the same breath, he simply said, if I've captured him correctly, he simply said he can deal with this even during the course of tomorrow in the morning. because in any event, he was not supposed to be, in fact, finalized with his submissions for the purposes of today. That's the essence of what he said later on. And for that matter, my lady, the matter is indeed set down for 5 days. Today is the 3rd day. Up and
Mr. Keller, I'm sorry, you froze out completely. I missed the last part. Your sound is very bad. It's very it's breaking up quite badly.
Yes, not. Must.
No, I'm not. I'm hearing. I heard one word and then you go off and it's very, very bad. The sound is very bad. I heard up to the point where you said this is the 3rd day, and that's all. I haven't heard anything else since then.
I'm saying that, my lady, he has not indicated to you that the consideration and, in fact, and the opportunity that he needs to consider and deal with these points of law will take him beyond tomorrow and possibly Friday. He has not indicated that, my lady. And, my lady, flowing from that, my lady, earlier on, he simply said this issue was also raised by one of the respondents. I do not, my lady, if that is the case, my lady, what harm or prejudice will he suffer? Because in the process of answering to that one, he might as well be dealing with the one that I'm raising. So, my lady, I submit that, my lady, under those
circumstances. I'm sorry to interrupt. I'm not with you. Which point are you talking about that it was raised by one of the other respondents? I'm not with you there.
And excuse me, refers to Rule 53. Rule 53.
Yes.
Rule 53. And the other point that has been raised as well by the other party is the issue of lack of condonation for the unreasonable delay in launching the review application.
Okay, just give me one moment, because my understanding is he said the issue of the record in terms of Rule 53 was a concern by other respondents, but they didn't pursue it. Not that they pursued it in the course of this hearing. That's the way I understood it. Did you understand it differently?
My lady, I agree with you fully in that regard. And he has not also, my lady, taken you into his confidence and told you, if it's mentioned in that fashion, he had taken a stance of not dealing with it in future because it has not been pursued further. He has not indicated that it was his intention not to deal with it because it was not vigorously pursued. He has not said that. And secondly,
well, does he have to say that? I don't understand. Does he have to say that he's not dealing with it? Because prior to the commencement of this hearing, that was not pursued by the other respondents, and therefore he considered it a non-starter.
Yes, sir. I understand.
I want to understand exactly what is it you say.
I understand that, Marie.
Now, I can't hear you. I'm sorry.
The point that I'm driving home, my lady, is that. Can you hear me now, my lady?
I'm struggling. I'm really struggling to hear you. Yes, you say the point you were trying to drive, and then it got cut off again.
The point that I'm driving home, my lady, at least, my lady, he concedes, the applicant concedes that the point, even though it was not pursued, but it was brought to its attention through it being mentioned, in fact, by one of the respondents. That, my lady, under the circumstances, brings me to say in my submission, it's not for the first time for them to know the existence of Rule 53 record point. It has been brought to their attention earlier on. So it's not entirely new. What is new is the first respondent dealing with it. And then again, my lady, in as far, my lady, as my learned colleague, Mr. Tsatsawana, is concerned, Mr. Tsatsawana eloquently dealt with the application of PAJA. Application of PAJA in this particular matter. I believe, my lady, once Mr. Tsatsawana touches the issue of Paja, it goes without saying that Rule 53 is married to Paja. You cannot apply Paja without the Rule 53. So in dealing with the application of Paja, surely he has to deal with, in fact, the implications that flows from the application of Paja. And my lady, in that particular regard, I do have, my lady, a judgment. Lawyers for Human Rights. I'm going to give you the full citation. I'm going to give you the full citation of those cases, my lady, shortly. Just 1 second, please, my lady. And my lady, another judgment that I'm going to deal with here in the form of persuading her ladyship is the recent judgment of the Democratic Alliance.
But you are now in reply. You are raising cases which, you know, the others have not had an opportunity to consider. You have to reply to what has been put forward by the applicant. Now you're raising, you know, this is what I'm saying. He's saying you did not raise these things in your pleadings as you had indicated. But now you're going beyond that and raising more cases, which he's not now had an opportunity to consider. So I don't think it's appropriate at this stage to do that. You have to stick by, yes, you have to stick by what you have raised in your argument, to which the applicant has answered, and you now have a responsibility or the opportunity to reply to exactly what he has said. But you are raising other issues now.
Thank you. I hear you, my lady. In that particular score, my lady, the point that I was trying to make is that, my lady, it's not a question of referring to the principle itself, my lady, but it's a question, my lady, of the fourth respondent trying to marry, in fact, the provisions of Rule 53 and the Paja. That was the only point that I wanted to make, that in those two cases where judicial review was dealt with, the Rule 53 was strictly followed, and such has been confirmed by the CC judgment, which if in fact we go beyond this stage, I will take you through them. However, my lady, the yardstick, my lady, the yardstick, my lady, that is applicable in determining, my lady, as to whether, in fact, these points are covered by the pleadings. It's not, my lady, a complaint in the answering affidavit. None of those judgments are saying that. It simply says, I'm willing to go, my lady, to one of those judgments. It must be apparent in the pleadings. We need not to raise a complaint in the pleadings. That is not what is being required of the fourth respondent. It must be apparent.
If I understand you, you say it may not be raised in your papers, but it has been raised in the pleading. So you're now relying on what was being raised by other respondents. Is that how I must understand this?
No, I'm not going to say that, my lady. I'm going to say this, my lady, primarily. I'm going to say that, in fact, my lady, as a secondary point. But primarily, my lady, what is apparent in these pleadings, both in the notice of motion, is that, my lady, if I can draw your attention to the notice of motion of the founding affidavit of the very same applicant that has, in fact, dragged us to the tribunal, is, my lady, the format which has been used. It's apparent from the format. The format that has been used, the document that I'm referring to is 078-1, 072, 2, 078, and 4.
What is it that you're talking about now? Because now you're introducing something else, which you ought to have done before Mr. Arendse responded. Now you're going to the notice of motion. He's basically responded to what you have said. But now you're building your case again. It's as bad as building your case in reply when you're filing your various affidavits. This is not in response to what Mr. Arendse has raised.
Can I align it? Can you allow me, my lady, to align it to the fact that Mr. Arendse is saying that there is nothing in the pleadings that we are complaining about in as far as these points are concerned. All I'm saying is that, my lady, we need not to complain in line with the case law, but the issue must be apparent on the pleadings. And the pleadings that we have a notice of motion, the founding affidavit, the answering affidavit, the replying affidavit. Those are the pleadings. The judgment does not specify as to which pleadings, the ones that belongs to the fourth respondent, which is the...
You've frozen up again, Mr. Keller. I can't hear you.
Humble approaches, my lady. So, my lady, the point that I was making, humble apologies, is that, my lady, the judgment does not differentiate in as far as to which pleadings, in as far as one can say it's apparent from them that the point must be raised.
I accept that. I'm just now trying to figure out whether you're making the other point. When you say the pleadings, what are you referring to?
I'm referring to, my lady, to the document and trying to create a connection between the pleadings and the absence of compliance or non-compliance, humble apologies, with Rule 53, that it is apparent even from the notice of motion, the format that they have used in the notice of motion does not, under the circumstances, accord with what is stated in Rule 53.
All right, let me just stop you right there. Let me just stop you right there, because now we're going into an area that I need to not consider before I consider the issue of why you have filed at this hour. I'm not hearing anything about that. The fourth respondent, like every other respondent, was given more than sufficient time. Their timelines were set, but there was no compliance therewith. And that is more important for me at this juncture, to hear what is the reason for that. You haven't filed a formal application for condonation, which is required. You failed to do that. I'm not hearing why that hasn't been done. Neither am I hearing why I should, in complete contravention of the timeline set as well as the rules, that I should admit this application.
My lady, I can't take it any further than what I've said, Yala, in as far as my involvement in the matter is concerned. And secondly, in as far as the case law, my lady, does not envisage a situation whereby, my lady, we have to apply for condonation in raising points of law. It simply says, even at the level of an appeal, that one at the level of an appeal.
I think you're misreading the cases. It's not a question of you don't have to apply for condonation to raise points of law. You have to apply condonation for not observing the times set in the rules for doing so. That's the important thing. And that's what I want. Mr. Killer, I'm going to interrupt you. I've got a message on my screen to say my battery is running low. I'm just going to log off for a minute just to plug my computer back onto charge. I'm going to just log off for a few minutes. I'll log back on just now. Thank you. Okay, I'm back. Mr. Keller, are you there? Mr. Keller?
I'm sorry, my lady. He seems to be on hold. I'm not sure why.
Okay.
Yes. Let me just try to get hold of that, Tani.
Okay.
As a pleasure to court, my lady.
Mr. Keller, are you back with us?
Yes, I'm back, my lady. Thank you so much.
My apologies for that. Yes, I didn't want my computer dying on me while you were talking.
Thank you, thank you. So, my lady, in essence, my lady, there is no new issue that we have come up with that will warrant the applicant to deviate from what he has, in fact, done in his papers. But the point, my lady, ultimately, that the fourth respondent wants to drive home is none other than compliance with PAJA, which has already been raised because Rule 53 is well connected to PAJA. So, in essence, my lady, the issue of Rule 53 is an extension of an argument that says that there was a duty on them to apply PAJA, and flowing from PAJA, they ought to have applied Rule 53. So, my lady, there is nothing new that we are coming up with. It has been raised, and it's apparent from the papers that PAJA was not applied. So that's the argument that the fourth respondent, wants to advance, in fact, in as far as that particular, in fact, issue under Rule 53 is concerned. Because Rule 53 does not apply on its own. It has to be done under PAJA. That's what we are driving home, and that issue has been dealt with by Mr. Chawan.
Thank you. Is there anything further that you wish to say?
Secondly, my lady, in as far, my lady, as what was required from my colleague regarding the prejudice, my lady, I would like to emphasize this. Is that he has not addressed us, my lady, that the issue of PAJA connected to the issue of Rule 53 is going to take him beyond Friday or tomorrow in dealing with it. You do not have that, my lady. And secondly, my lady, you will address, my lady, on whether these points are points of law or not. My lady, I believe that is a secondary inquiry, which ought to have been dealt with if your ladyship agreed with me. But for now, my lady, we are dealing with the notice itself. Your ladyship, just before the short adjournment, has indicated that there is, if I heard your ladyship clearly, that there is no bar on the fourth respondent to raise these points of law. But the only issue is the issue of the notice itself. That, my lady, if I've captured you clearly, I submit that, my lady. If, my lady, I can do that, my lady, orally, what difference, my lady, does it make, my lady, when same is being reduced into writing? And the advantage of reducing it to writing, my lady, it's more, my lady, compared to the one that is compared to standing up and deal with them at the time of making one of a notice. At least it affords the applicant an opportunity to read it as far back as Monday. However, my lady, if I just stood up now and dealt with those points, my lady, he was going to complain more because it was going to be for the first time for me to deal with them at the time of addressing you. So all I'm trying to say, my lady, in my submission is that, my lady, there is no, my lady, harm on the part of the respondent, no prejudice that has been demonstrated in as far, my lady, as these issues are concerned. These issues are not new, my lady. He has touched as well on the issue of the unreasonable delay. The unreasonable delay, my lady, is well, my lady, in fact, apparent from the papers. The date of this particular tender, the date of the launching of this review application.
Don't go into that now. What he was saying is you did not raise that in your papers. Now you're raising it as an afterthought. And that is the point that he's making, which is a factual situation. You have not raised that in the papers. It's not been raised by you in the papers.
My lady, perhaps, my lady, I need, my lady, to deal with that part decisively, my lady, and emphatically. in fact, in so doing. The judgment that I've referred to, my lady, the High Court judgment that I've referred to earlier on, it exactly deals with that point. Paragraph 33, our courts have permitted an appellant to rely on a new point of law on appeal, as a court will not be precluded from giving the right decision on accepted facts merely because a party failed to raise a legal point as a result of an error of law on his part. And secondly, my lady, the other judgment deals with this point, my lady. I'm not going to read this, but I already read it, my lady, already. But in this particular case, my lady, in this particular judgment, it's clear, my lady, that it should not be like an opportunity to raise these points of law should not be lightly denied on the basis that, my lady, perhaps there was a delay in raising them, perhaps there was an error of law. The judgment says that, my lady, that is not sufficient to be the reason to prevent a party from raising point of law. And what is interesting, my lady, is the judgment, my lady, that I've referred to earlier on, the Kusa judgment. The Kusa judgment, my lady, puts it plainly clear as to what, my lady, is expected. Even the court, my lady, without, my lady, any point, as Mr. Arens has pointed out, raising such a point, the court can meromoto, raise it and call the parties to deal with it. And the reason for that, my lady, is clearly stated on paragraph 68 of the Kusa judgment. Otherwise, the result will be a decision premised on incorrect application of the law. That will infringe the principle of legality. If, my lady, one has a regard to that particular paragraph, I'm in possession, my lady, as we speak, without delving into the merits of the case. The DA judgment, which is the CC judgment.
Well, now you're frozen up again.
And the application of Pacha and Rule 53.
Froze out there, Mr.
So, my lady,
Mr. Keller, I didn't hear the last part of the submission. You were frozen out again.
Thank you. Humble apologies, my lady. Humble apologies for this, my lady. I'm saying, my lady, on the issue of the last part of the Kusa judgment, it simply says, my lady, if you have captured me in that regard, that the failure.
No, I still can't hear you, unfortunately.
Whereby the judgment of the court will be premised on incorrect part of the law. And in this instance, my lady, the fourth respondent, my lady, is armed with a DA judgment, my lady. A constitutional court judgment, if not a CA judgment.
Mr. Keller, what you're doing now is not correct. You're simply not correct. You had your chance to put your propositions forward. The applicant has responded, and now you are reintroducing things that he did not have a chance to respond to. I cannot continue like this, because now then what you're raising now must give him a chance again to respond to. This is simply not how things are done. You must put everything to the court before somebody else has the opportunity to respond. Now you are bringing more and more and more cases. I'm sorry, I cannot allow this. You must respond to what he has said.
My lady, if I can qualify my submission in that regard. If I can qualify, my lady, my submission in that regard, my learned colleague was afforded an opportunity, my lady, in fact, to make a submission to an extent that these points are not points of law according to him. He said that, my lady. He criticized them for not being points of law.
It was his, he raised that in the context of the requirement that it must be apparent from the pleadings. And that is why he says, if you look at he referred to your answering affidavit and said, it's not raised there specifically. Therefore, it cannot be a matter that is apparent from the pleadings. But, and that is so, because if you look at it, you do not say anything about, firstly, the failure to deliver a record. You do not mention Rule 53 in the answering affidavit. You do not raise the issue of the lateness. Your dispute is on material facts. You've covered that in your answering affidavit. And you conclude by saying your dispute is regarding the issue of overcharging and the computation of the figures, which should be referred to oral evidence. And that is the context in which he says these are not points of law which can be allowed. So it's not that he is now going into the merits. He raised it, as I understood it, in the context of whether it arises out of the pleadings to enable the court to decide whether I should allow these points of law. And it's not a question of allowing the points of law. The question is, why wasn't this done earlier? So he took it further to say these are not even points of law. So therefore, that is an added reason why this application should not be allowed to be admitted at this stage. So that is the context in which he raised it. And that's how I understood it, unless you understood it differently. But you cannot now go and re-argue the points that you ought to have brought up before the applicant was given a chance to respond.
My lady, I will confine myself. I hear leadership sentiments. I'll confine myself, my lady, to what I've made submission on earlier on. The submission by my lady colleague on behalf of the applicant is incorrect. To an extent that, my lady, the case makes reference, not in fact to a complaint, my lady, in fact, in the body of the answering affidavit. The case law that I've referred you to, my lady, even the Kusa judgment does not make, my lady, in fact, a situation whereby we have to plead that, my lady. But what is apparent from these three judgments is that it must appear in the pleadings. And, my lady, I emphasize this. The pleadings in this context, notice of motion, founding affidavit, and the answering affidavit, inclusive of the replying affidavit. So in that particular issue, my lady, if it is apparent, it must be apparent in one or two or in all of those pleadings that I've just mentioned. And I've demonstrated, my lady, that it is apparent even on the notice of motion. It is apparent. It is apparent, my lady, even, my lady, on the non-compliance, in fact, with Rule 53, in as far as, in fact, allowing 3512 to replace Rule 53. It is apparent that 3512 ought not to have been invoked.
Mr. Kera, I must stop you there. You seem to miss a fine distinction between what you're asking and what the other respondents have raised. What they have said in respect of Paja is that the applicant was wrong to proceed on the basis of the constitutional illegality review. And they should have he should have gone, or they should have gone in terms of Paja. And the reason why that was, and that's because it's not a self-review, it's a review in the interests of the public and so on, and therefore Paja applies. What you're saying is that he did not comply with Rule 53 because he has not provided the record. It's a different thing. The other respondents have put forward is that the court must decide whether the review proceedings in terms of the legality principle is correct, or whether in fact the respondents are correct to say he should have gone to Paja. We're not even getting to this point of he has not complied with providing records in terms of Paja. It's whether Paja ought to have been engaged. That is the consideration this court has to make, or determination this court has to make. You're missing that fine point, because you are going into compliance with Paja as though the applicant has brought his application in terms of Paja and has not complied with the procedural requirements for furnishing records. And that's incorrect. And that certainly does not appear from any of the papers. And it does not appear from the founding, answering, and replying papers that he has engaged the mechanism or the machinery of Paja. So that's what I'm saying. You're missing that fine distinction.
My lady, I hear what your leadership, in fact, is saying in this regard. However, my lady, let me, my lady, try to clarify, my lady. Seemingly, my submission has not been very clear to you. My lady, I've said earlier on, I'm repeating that submission, that connected
to the application of PAJA is Rule 53. I've used the term that Rule 53 is married to the application of PAJA. You cannot separate the two. You can't separate the two in terms of case law. It flows from the application of PAJA that Rule 53 should be applicable. That's what the judgment, in fact, of which I cannot go to it at this stage, the human rights judgment is saying. I'm saying that, my lady, flowing from that, my lady, it is also abundantly clear and apparent from the pleadings that instead, my lady, of Rule 53 flowing from PAJA, Rule 3512 was infused, in fact, in judicial review as the mechanism.
I'm sorry, Mr. Keller, the sound, I cannot hear you. I didn't hear you. Your sound is frozen out and then you came back on. I simply could not hear the last bit of what you said.
I'm saying, my lady, I must apologize for that, my lady. The network in this particular area is very bad, even on calls, my lady. All I'm saying, my lady, is that, lastly, that it is apparent from the papers that instead of Rule 53 flowing from the application of PAJA, of which my colleague has dealt with it, Rule 3512 was infused and replaced by, in fact, Rule 53 in as far as, in fact, the discovery or the dispatching of documents is concerned. I'm saying that, my lady, that is the point. That is apparent from these pleadings. It is apparent. And, my lady, we are saying it can never be that Rule 3512 can replace Rule 53 judicial review application. So, my lady, that is what is apparent from these papers or from the pleadings. It is very much apparent. If PAJA was applied properly in line with the decided cases, Rule 53 ought to have flown from such an application of PAJA to the exclusion of Rule 3512, which is not applicable in judicial review. So, my lady, with regard to costs, my lady, there is no basis upon which the applicant seek costs against the fourth respondent. With the recent judgment of the CC, I believe it came out 2 days ago. A defense, my lady, if I've read it properly, my lady, against costs is one of, in fact, intimidation for the other party not to participate fully. In fact, having an idea that perhaps what I'm going to raise will invite costs. Let me remain silent. So, my lady, in this particular regard, my lady, in fact, in the absence of them explaining that they will need more time to deal with this beyond tomorrow and beyond Friday, what have they done up to so far since Monday? They have not given that explanation, my lady. They have not demonstrated any prejudice, my lady. And these particular points, my lady, are very much, my lady, apparent from these papers, and some of them have been vigorously raised by the other respondent to punish the fourth respondent for an opportunity to have a say in those issues, in those points, my lady, will be tantamount, my lady, on the part of the applicant to intimidate the fourth respondent in these particular proceedings, so that, my lady, we can be afraid of, my lady, dealing with this going forward. And, my lady, no court order is warranted, my lady, under these circumstances. And for that matter, my lady, in all fairness, my lady, he has, my lady, allowed many parties these proceedings, in as far as, in fact, the lateness of other documents, including the one, if I'm not mistaken, of filing, in fact, today and yesterday. He has not requested any cost. But in this particular instance, my lady, without just demonstrating any prejudice, he is just saying that we must be hit with costs because of the lateness. My lady, that is not how litigation should be conducted, my lady. There is merit, my lady, in what the applicant is saying. And, my lady, these are very much issues, and we have relied on case law. If the leadership is not with us, there is no basis, my lady, in fact, to settle the fourth respondent with costs in as far, my lady, as this particular matter is concerned. And for that matter, my lady, even there, my lady, he is talking about Rule 30 notice. He's talking about Rule 30 notice. He has not even embarked on Rule 30 notice in as far as rejecting the notice in terms of Rule 653. And for that matter, my lady, on our side, without embarking on a Rule 30 notice in this regard, but my lady, we have managed to raise that, my lady, these are the issues. My lady, those will be my submissions, unless the court wants me to address on a particular issue.
No, thank you. I'm just going to need about 10 minutes and then I'll come back and give a ruling.
Thank you.
Stand down for a bit. Right, good afternoon. Are we all back?
Yes, sir. We're back, my lady.
Good. Well, I've prepared a very, very short ruling in the time allowed to me, and if it is at all necessary, I might expand on this later. So I'll just quickly read what I've read, what I've written rather. The hearing of this matter commenced on the 14th of November 2022 after many months of being case managed and dates and timelines having been agreed by all parties. The respondents had up to the 29th of July 2022 to file any objections or notices that they wished to take points of law. The fourth respondent failed to do so and even failed to file its heads of argument by the agreed date of 10 October 2022. On the morning of the 14th of November 2022, while the hearing of this matter was underway, the fourth respondent filed an application in terms of Uniform Rule 6.5 sub D sub 3, in which he seeks to raise certain points of law. No application for condemnation for such late filing accompanied the notice in terms of Rule 6.5. Mr. Keller today correctly argued that a point of law can be raised at any time, and in certain instances, the court in the matter can also, well, in this case, the tribunal, may do so miru motu. The two requirements for this is that such points of law must be evident from the pleadings, and also the issue of, secondly, the issue of prejudice that will be caused to any other party. He argues that these are important points that he wishes to raise and should be allowed to do so. I note that no explanation was tendered as to why this application was filed after the commencement of the hearing in this matter. Contrary to what Mr. Keller argued, namely that it appears from the pleadings that the non-compliance with PAJA was raised, it appears that in its answering affidavit, as he belatedly argued, even the amended notice of motion, founding affidavit, answering affidavits, and replying affidavit, this is not the case. The point about PAJA was raised by most of the other respondents and thoroughly canvassed. The nub of those arguments was that the SIU wrongly followed the review proceedings on the basis of constitutional illegality and ought to have followed the review proceedings in terms of PAJA. The reasons for these submissions were also thoroughly canvassed. Mr. Keller appears not to appreciate that that the relief he is seeking is non-compliance with Uniform Rule 53, which must surely arise only if the review proceedings in terms of PAJA were followed. This tribunal has still to determine if the constitutional illegality review was correct or not. Mr. Arendse, in response, pointed out that the fourth respondent makes no mention at all in its affidavit about Rule 53, nor of the lateness of the filing of the review application, which the fourth respondent now seeks to do. The fourth respondent raises the issue of the notice of amendment being filed without a notice to amend in terms of Rule 28. That too was not raised in the pleadings. In any event, as Mr. Arendse correctly pointed out, that is not a point of law as envisaged by the cases that Mr. Keller has referred to. The issue of material disputes of fact have been raised and dealt with in the fourth respondent's answering affidavit, and in fact, he suggested that such disputes as regards the overcharging and quantum thereof be referred to oral evidence. With regard to prejudice, Mr. Keller boldly suggests that no prejudice is occasioned to the applicant who has not said how it will be prejudiced. The very fact that this application has now occupied an entire day of the time allocated to the hearing of this matter is prejudice enough, not just to the applicant, but to all the other respondents who have opposed this matter, as well as the tribunal. Mr. Arendse has explained that as the hearing had already commenced, he was occupied with formulating responses to the arguments of the other 7 respondents who were opposing this matter, and that, in my view, is a perfectly valid explanation, because one can only do so much after hours, and each day this tribunal sat until 4 o'clock. He did not have Mr. Arendse, that is, did not have the time to give attention to this application, and he was given that time during the lunch adjournment today to do that. It is not understood why Mr. Keller argues that an explanation was not given by the applicant. The fourth respondent's non-compliance with the rules and agreed timeframes is blatant and unexplained. The so-called law points he seeks to introduce now are without merit, and in my view ought not to be allowed at this late stage. I accordingly refuse the application in terms of Rule 653D. The question of costs will stand over to the end of this matter and will be determined at that stage. Thank you.
Can I now proceed, Marek, to deal with other issues in the light of your ladyship's ruling with this regard?
Absolutely. Just give me 1 minute to clear my desk in front of me. Right. Thank you, Mr. Keller. You may proceed.
Yeah. In the light of this ruling, my lady, I would like to seek guidance from you. In fact, in as far as aligning myself with what has been raised by other respondents, in particular to the application of PAJA. Can I touch on that? The lateness?
Yes, well, only to the extent of the whatever they have said in respect of PAJA being the correct way to go, not compliance with Rule 53 as you would need to do if you followed a PAJA review procedure, because a PAJA review procedure was not followed here. So therefore, I'm saying you have to confine yourself to your pleadings and your heads. You have filed very extensive heads.
Thank you, my lady.
And
Can I,
and if there's anything as per the agreement with Mr. Arendse, if anything new has been raised,
align myself with the today and expand.
Just a minute, let me finish. With what we've agreed with Mr. Arendse is that anything new in the heads, in your heads, the 7th respondent and the 6th respondent, anything over and above what's been raised in the pleadings will be dealt with him in reply. So therefore, if your heads have raised anything that is not in your answering affidavit and other pleadings, he will deal with that in reply. So please confine yourself to your pleadings and to your heads. Thank you.
Thank you, thank you. In as far, my lady, as what my colleague, Mr. Tsatsawana, is concerned, particularly the submission, I would like to align myself with the fact that the tribunal is not empowered. My lady, I agree with that submission.
Well, you can align yourself with it, but that is as far as I'll allow you to take it, because that's not what you've raised in the pleadings.
Yes, I will just align myself and move forward, my lady.
Yes.
I align myself, my lady, with my colleague, in particular, Mr. Tsatsawana, in as far as his submissions are concerned on the issues of PAJA, on the issues of the jurisdiction of the tribunal, in as far as, in fact, adjudicating over judicial reviews. We'll also align with him in as far as, in fact, the delay, the unreasonable delay in bringing this application. I align the 4th respondent's case to that, my lady.
Yes. You may continue. You may continue.
In as far as this particular case is concerned. Yes, my lady, I must apologize. Sometimes I appear as if I'm speaking whilst we are speaking. What I'm receiving is that, my lady, sometimes you finish and then it takes time. Sometimes I can't hear you and then I talk, whereas we are talking. I must apologize for that. It's not a question of I'm talking whilst we are talking. Is this the system or the device that I'm using is delaying, in fact, what you are saying? So I must apologize for that. For instance, now, in fact, you have long finished, but we are still talking. I can see the movement, but I apologize for that, my lady.
All right. Continue.
Thank you. My lady, I align myself entirely with, in fact, the argument of Mr. Tsatsawana in as far as the merits of this matter is concerned. My lady, in as far, my lady, as, in fact, the prayers in as far as the setting aside, in fact, of the service level agreement between, in fact, the 13th respondent, the 16th and the 17th respondent in this particular matter, I submit that, my lady, there is no basis that has been laid out in the founding affidavit for a for the setting aside of that particular, in fact, my lady, a service level agreement. I will expand on that, my lady, by saying that, my lady, he is also asking for a declaratory order. My lady, let me start with the declaratory order. In my view, my lady, in my submissions, those are two distinct in fact, causes, in fact, of action and remedies applied for, my lady. The declarator alone, my lady, if one looks at the Kaukeni judgment, it can only be considered in the clearest of cases, of non-compliance with the procurement processes. If your ladyship, I will upload this judgment later on. In the Kaukeni judgment, my lady, the merits of the case, the facts of the case, in summary, are as follows. The company, my lady, had, my lady, a conversation with the municipal manager.
I didn't catch anything. I just caught half a word.
Yeah, that, my lady.
It's really very, very difficult. Sorry, Mr. Keller. It's very difficult at this point to hear you. I don't know if there's anything you can do to improve the sound quality. What happens is, one or two words come through and then it freezes, then it breaks up. So I'm not hearing sometimes an entire word. I'm just hearing your voice coming up, and that's it.
I must apologize for that, madam. I'm trying another device, the third one, my lady.
Well, if it's the network, I'm not sure whether the device is going to help you.
The network, my lady. It is the network. Thank you, my lady. I don't want to waste your time, my lady. My lady, all I'm saying is that, my lady, the declarator, my lady, in these cases can be granted in the clearest of all cases. While I'm saying that, my lady, the case of Kaukeni municipality, my lady, the company there, my lady.
Sorry, what's the name of the case again?
Thank you. Kaukeni municipality. I'm going to give the full citation, my lady, shortly. Is the Kaukeni judgment, my lady, going to give you the full citation of. Is Kaukeni QAU?
Just a minute. QA.
UKE. NI.
Yes, municipality.
A local municipality versus general trading. In brackets 324/08, in brackets 2009, Zaska 66, 29, May 29 May 2009. Without wasting your time, my lady, in this particular issue, the facts of that case, my lady, are very clear. First of all, my lady, the agreement for the respondent, for the applicant, that is, for the respondent, general trading, was oral. It was oral, my lady. It was done between him and the municipal manager. And the second agreement was done in conjunction with the municipal council, between municipal manager, the municipal council, and general trading. The third one, my lady, that caused, my lady, a lot of problems for the general trading is, my lady, the clause in the agreement. There was a clause in the agreement. The clause in the agreement was, in fact, had a renewal clause. The renewal clause says that upon the expiry of the reduced oral agreement, which was subsequently reduced into writing after the expiry of the oral, it was subject to a renewal, if I'm not mistaken, of 2 years, if not more than that. Again, that was done between the municipal manager, the council, and the general trading. However, my lady, in the mix of things, my lady, in the course of those events, my lady, a new municipal manager was appointed. And when the general trading wanted to invoke renewal clause, the new municipal manager said no. There had to be compliance with the SCM, in particular with the procurement processes, to an extent that we are sending this out on tender in line with, in fact, the procurement processes. And then that's where the whole, in fact, issue, my lady, arose. To an extent that, my lady, in those cases, it's clear, my lady, throughout that, my lady, nothing was done in terms of the procurement process. There is no record of any process, my lady, that was undertaken by the municipality together with Mr. Usoro General Trading. To an extent that, my lady, a declarator at the end, my lady, was granted. The court simply said, in fact, there is not even a need to embark on purge. I believe one of the reasons was that no process of whatsoever was followed. No process was in fact supposed to be traced to an extent that the declarator was granted. So, Maledi, if I can, in the diagnosis of the case before you, Maledi, diagnose, Maledi, the process that was embarked upon by the fourth respondent. The facts of the
who knows? I missed that. Who knows?
My lady, if I can diagnose, my lady, what has happened in this particular case as compared to what happened in the Kaukeni municipality. In this particular case, my lady, the process, my lady, the procurement processes were there. First of all, my lady, as Mr. Tatawana has correctly pointed out, there was a decision on the categorization of the manner in which these services ought to have been procured. They were categorized under emergency, that there is an urgent need. That was a decision. There is an urgent need for this. That was the decision, services. And subsequent to that, there was another decision to simply say, by virtue of these particular services being urgent, we need to deviate from the normal procurement processes. My lady, that is a secondary decision that was taken. And my lady, I may as well submit that, my lady, those two decisions, as for now, as I'm going to touch on the other decisions, they are not before you for the purposes of reviewing and setting them aside. And my lady, it's not in dispute, if my memory can be stressed, to cover the entire bundles of this document. It's not in dispute that they remain in existence up until this day, those two. It's not in dispute that those two processes are well sitting or vesting under the SCM procurement processes. The issue of emergency or urgency, the issue of deviation is one of the processes as envisaged by the Act. Secondary to that, my lady, I'd like to emphasize again, there is nothing, my lady, that suggests that those decisions are no more or are no longer in existence. They are still in existence, albeit that they are not being challenged. Flowing from that, my lady, we submit that, my lady, unlike in Kaukeni, where there was oral, here, my lady, there were those two decisions. And the third decision, my lady, was to appoint. They decided to appoint, my lady, the service providers, including the PSPs. And, my lady, as if that was not enough, they allocated a budget of 50 million. That is the kind of decision. Which is the line those processes. And from database of that decision, let's appoint from the database the name of the fourth respondent. That is another decision that was taken by the applicant in this matter.
Sorry, Mr. Keller.
All I'm saying, yes, my lady.
I missed the whole lot of what you just said. You got up to 50 million and that's all I heard. Can you hear me, Mr. Keller?
He's frozen, my lady.
Sorry?
He has frozen, my lady. I think.
Yeah, no, I can't. Well, I'm not sure if he can hear us.
I don't think so, because I can hear you.
You can hear me. Oh, my goodness, this is a problem.
But the problem is on his side. Let's just see if he reconnects.
Or perhaps you can alert his attorney or him that he's completely frozen now.
Yes, thank you. Okay. My lady, I brought it to his attention that he's frozen and that we can't hear him. So
thank you, Mr. Tatsuwana.
He said he's trying another device. I think this will be the fourth.
I don't think that's going to solve his problem. He needs to move out of the area altogether and find a place where there's a proper signal. And I'm not sure that he's going to be able to do that now. Because now he's disappeared off the screen as well.
Yes.
My lady, unless Mr. Tatsawani wants to make further submission on it, may I suggest that we adjourn for the day and maybe start 15 minutes earlier? Or
I was going to suggest that we start at 9 tomorrow.
Or at 9?
Yes.
We certainly wouldn't have any objections.
Yes. Does anybody else have any problem with that? If we start at 9, because he's barely begun his argument, and I suspect he might be a while.
Well, lady, from our side, that's suitable.
Okay, thank you.
Fine with us as well, my lady.
Thank you. That is Mr. Ellis. Mr. Klopper, Mr. Ellis. Who else? Mr. Tatsawana, is that okay with you?
Yes, we are happy to start at 9 o'clock tomorrow.
Great. And Mr. Hodis or Ms. Governor?
Yes, my lady, it's fine with us.
That's good. Mr. van der Vyver?
Happy with that, my lady.
Good. I think I've covered everybody now, haven't I? But now I need to make sure that Mr. Keller knows that we're starting at 9 o'clock. Otherwise, it's not going to help us, will it? Mpo, can I ask that you perhaps communicate with him, or Mr. Tatsuwane, if you are able to do that, because it doesn't look like he's able to connect at this point. Will you be able to inform him that we will take the adjournment 9, but we're starting at 9?
Yeah. He's connected again, my lady.
Oh. I can't. All right, let's just give him a minute or two and see whether he comes back on.
Okay. You can mute your device and this mine comes in. Okay.
Thank you, my lady.
Mr. Keller, we said in view of the problems that you're having, the suggestion was we take the adjournment now for the day and give you a chance, and then we start at 9 o'clock tomorrow just to make up for all the time that we've lost today. Is that all right with you? Everybody else seems to be fine.
Yes, my lady. Reluctantly so, my lady. I was willing to proceed until 3. I don't want to
until 3. It's now 10 to 4.
Until 4, my lady.
Yeah, no, it just seems that your network is incredibly difficult. I would recommend if you could find somewhere to connect from where the signal is much better tomorrow, so we don't have the same problem.
Thank you, my lady. Can you hear me now, my lady?
Yes, I can hear and see you clearly now. But what I'm saying is that that's been the suggestion, that you continue tomorrow after you found a place with a more stable network.
That will suit me, my lady.
Yes.
And I apologize for this inconvenience.
No, well, technology does let us down at the best of times.
So, last time around, my lady.
All right, then we'll take the adjournment for today and we'll commence at 9 o'clock tomorrow.
Thank you, my lady.
Thank you.
Thank you, lady.
Thank you.
Right.